May I please, sir? I have to match item 22, my lord. Pass only for the day, my lord. 22.
Let the matter reach, we pass it on, not at this stage. Okay? Take it.
God bless you. God bless you.
Lord, I beg to mention item 4, my lord. For the day, my lord, kindly accommodate. I'm not feeling well, my lord, getting a vertigo. 4, item 4.
Let the matter reach, you may not be there, we'll pass on.
My lord?
We'll pass order, let the matter reach.
My lord. My lord.
Sure, I have the same prayer, Your Worship. Item 3, Your Worship.
We'll see, Mr.
For the day only, Your Worship.
We'll see. Let the matter reach.
May it please your lordship. Lordship, I beg to mention item number 1, lordship. The conducting counsel, Mr. F.E. Borbia, he has some difficulties today, lordship. So kindly the matter will be adjourned only for the day.
We'll see, item number 1. Let the matter reach.
Yes, lordship. May it please your lordship. I beg to mention item number 14, lordship. Today our conducting counsel is out of station, lordship.
What is his name?
S. Boro.
There is no letter of absence. There are 2 other councils.
Yes, lordship.
So let the matter reach.
My pleasure, Lordship. Lordship, I beg to mention item number 8, Lordship. That's the matter maybe list after 2 weeks, Lordship. Lordship, we are not aware of the present status of the petitioner. We are trying to contact, but phone number is sent, Lordship. We will send a letter tomorrow, Lordship.
There is a stay order, right?
Lordship.
We'll vacate it.
Lordship.
We'll vacate it. We'll get the communication immediately.
Lordship. Matter may be released. Matter may be released, Lordship. We are not aware of it.
Vacate the stay orders. Immediately the client will contact you. That's the best way. Right?
Lordship, let matter may be released, Lordship. Must-
We will take up those matters first where there is no LCS and certain matters in the admission in orders. Okay.
May it please your lordship. Lordship, in this case, this petitioner has been declared as a foreigner opinion. Lordship will find on page 72, lordship.
Only the petitioner's name first entering the.
Here, her name first appear after marriage, Lordship, in 1997, page 40, Lordship.
At that point in time, how old was she?
Lordship, can we come to page 40, Lordship?
How old was she at that point of time?
That time, Lordship, 40 years, Lordship.
So for the first time, her name figured in the total is when
Yes.
was 40 years.
Yes, Lordship. Only the Lordship, the tribunal has opined that Lordship, she could not link with her father, Lordship. But her father's document is there. Her father died 40 years ago and her mother died almost 18 years ago, Lordship. Therefore, her brother is there, Lordship. There is a family dispute. That time, brother has not come up for depose evidence in favor of this petitioner, Lordship. Now he willing to depose, Lordship. Otherwise, brother's name is appeared there. This petitioner name appear in the NRC also, Lordship, drafted NRC, that is on page 53, Lordship.
Application number 2247, with copies of both of them. 2016. Final order of the opinion to the 3105/2024.
May I pray for interim lordship? Hello, please.
Yes, Mr. Sudha.
My lord, Michelle, my lord, there is a typical mistake in page 40. Annex 3, my lord. First part is, my lord, Mohammed. It will be Mohammed Afaz Sheikh, but it is wrongly typed as Azaz Sheikh, my lord, in the vernacular, my lord, at page 41. So maybe, my lord, correct this mistake, my lord. And my lord, father is Afaz Sheikh and having land purchasing deed of 1958. Admittedly, father could not be enlisted in the voter list because he died before 1966. When the petitioner was of 3 months old, and mother, my lord, left the parent house, went to the mother's house, maternal grandparents' house, and she got married second time. So the petitioner was looked after by the maternal grandparents and appeared voter, and the subsequently, my lord, only the parents could not be shown as a voter, but grandfather has the land property, land purchasing deed of 1958. Apart of this merit, my lord, we have also raised the my lord, maintainability of the proceeding, because the charge is two. Charge is not one specific. In the notice, my lord, indicated, page 30. And paternal uncles were voted of 1966 onwards. One of the paternal uncle was examined. Maternal uncle also examined, my lord. One maternal uncle also examined.
Yeah, see, Case number 7846 only 3 of 16. Current Foreigners Tribunal number 1 Barbara. Mr. You correct it and put your initial. And they did, okay?
Yes.
Yes, Mr. Sharma, what is your instruction?
No. Lordship, can it be on day after tomorrow, Lordship? I did not get it.
Prepare the council for the. Under standing council home department.
If I may humbly pray, Lordship, may dispose of this matter, Lordship, in terms of similar order passed by this honorable court in WPC 267 of 2022, Your Honor. Because it's a devoter matter, Your Honor. Because anyway, he will have to prove his citizenship before the Foreigners Tribunal, Your Honor. So let the direction be issued to the SP border, Your Honor, So he may verify whether any reference is made or not. If there is no
That's
reference,
what we want.
if no reference is made, a fresh reference may be made.
Let there be an action. Let us see. Why they are sitting over the matter. Yes.
Day after tomorrow.
Declare a mistake.
On 21. I don't fix on 21 here. Sure. That matter is fixed on 21st.
Okay, on 21st.
Public.
My lord, in this case, my lord, one minor boy was tortured in the police custody, my lord. Kindly see the last orders. My lord.
Yes,
No time was-
medical report is here. What do you have to say? What do you have to say?
My last occasion, my lord, government was supposed to
It is not because the petitioner, the victim was in police custody.
it was
It
admitted,
was
my
found
lord,
that, how it is related to the fact that the victim was in custody.
my lord, they admitted, my lord,
There are
one
some
day.
permanent ailments, right? You have to establish the facts. Only because he was kept in custody, he suffered from this permanent ailment. Where is that? That is the reason time was given to you.
My lord, before the last order, Peru's earlier that orders, my lord, where the LS police personnel was
Which order you are talking about? Which order? Dated?
my lord, after some time.
Say very specific. On 23rd of August 2023, the court passed an order. You took time to examine the material available to you to substantiate that the medical condition of the victim boy as depicted in the medical report is relatable to the event of the victim boy being taken into police custody. The medical report is very clear. Right? There are some permanent ailments and nothing to do with any such reason for keeping the boy in police custody. That is why you're supposed to clarify. Where is that clarification?
My lord, it is established,
That is why time was granted to you to establish how it is correlates to you, the boy keeping in custody.
But 1 week time may be given, I will file
Already it is
affidavit.
there. From August, the matter is pending for that purpose only.
Yes,
Thereafter, another affidavit was.
I will file
filed
a
with the-
affidavit, madam, in this regard, madam.
What is the medical report? Tell us.
The medical report was not given to us, my lord. That is before your lordship, my lord.
Not given to you. Is it?
Yes. So there was initial medical report was annexed in read petition, my lord, page number 16.
Say, as per the direction of the court, the victim was examined by the medical board in the Guwahati Medical College Hospital, right?
Yes, madam.
That report indicates everything. That report indicates everything. That is the reason the court directed you to make your substantive claim.
My lord, 1 week time may be given, granted, my lord, I will file an affidavit, my lord, in this regard. Compensation के नियंत्रण के लिए यहाँ पर कोई काम नहीं
Yes, Mr. Sharma, Prem Sharma.
Lorships. Last order हमारा रिस्क है.
Now, what happened pursuant to the order of 12th May 2023, direction was issued to the OC Vidapur Police Outpost to register an FIR and to investigate the matter. Is that not you are appearing?
Yes, sir.
What happened?
No, no problem. But the FIR was registered and the case was investigated and charge sheet has been filed.
What is the finding in this assessment?
The charge sheet has been filed against the IO. Mulad.
For what?
In fact, Mulad, the allegation was that in police station, some
Injuries were found
yes,
on his
injuries were-
person
yes, yes.
while he was in, of course, whether it was in during his custody or it was outside the custody, it was not known, but it was found that he was having certain physical injuries,
Lordship.
right?
Yes, Lord.
And as per the medical report, those injuries were found there. So accordingly, the superintendent of police, initially the officer in charge of Vidapur Police Outpost was directed to register an FIR.
Yes, yes, Lord.
Then during investigation, what happened?
But বিনোদীবোৰ কেছটো তুমি চাই থকা নাই দিয়া লাষ্টত বাদ দিয়া তুমি মানে কেছটোত ফেক্টটো আছাতো ফেক্টত আছাতো But Lordship may kindly see the name of the informant. He appeared before the honorable court. Ultimately, an FIR was FIR was registered, and finally, my lord, after investigation, it was found that he was found guilty, my lord. The IO who has lost the FIR, he was found guilty, my lord,
For what?
for that offense, my lord. Kindly, my lord, come to the third page, my lord.
Yes. Yes, please.
Lordship, Lordship. Sorry, in the second page, my lord, particulars of accused person charge sheeted. Name Inspector Deepak Soikia. Second page, my lord. Deepak Soikia. Charge sheet has been filed against him, my lord. So record open jama. Report open jama. Photo please. Prosecution sanction has been taken from the competent authority and the charge sheet has been submitted, my lord. I have received the only, my lord, this form. In fact, the চাৰ্জশ্বিটৰ ডিটেইল কথা নাথাকে জানো কি কি কৰিলে কি নকৰিলে সেইটো কওঁ সেইটো কওঁ সেই বস্তুটো ডিটেইল কি কি কৰিলে থাকে নহয় আছে নাই? But possibly the case record is with in the court file, मतलब. Detail itu kok থাকে detail বস্তুটো কি কৰিলে কি নাই কৰিলে কি ক'ত আছে ক'ত আছে সেইটো পালো সেইটো পালো সেইটো পালো কিন্তু কি যে ডিটেইল যে এটা হেৰি থাকে সেইটো নাই এইটো ছেপাৰেট চিট এটা বুলি কৈছে But during proceeding of this case, medical report was called for. He was medically examined, and the report from the GMCH was called. And it was found in the report that he was having some difficulty prior to that incident. In fact, here the offense is registered under 342, 323, read with 75 of JJB Act, and he was of 16 years of age. That is the difficulty, Mulad. Otherwise, Mulad, his difficulty as has been alleged in the petition now, that has been examined by the medical board in the GMCH, Mulad. A report is before your lordship, Mulad. My family will never. Man, important find and can
সেইটোৱে বেছি জৰুৰী
আমাৰ আৰু এটা আছে কেতিয়াবা দিব পাৰিব ইয়াতে দিগদাৰ হ'ব নহয় সেইকাৰণে হয় নাই মই সত্যপতি থাকি যাম অলপ বিচাৰি ল'ব ইহঁতে কেতিয়াবা ইহঁতে কেতিয়াবা ইফালৰ পৰা সিফালে সোমোৱাই দিয়ে।
Legal report 2023. 100%.
মেডিকেল ৰিপৰ্টৰ কপি এটাও আছিলে লাগিব। লাগিব।
Was there prosecution sanction issued?
Yes, my lord. But the later copy I have given, my lord. After they said that I would like to inform you that after completion of investigation of the above referred case, the case is well established against the complainant Inspector Deepak Soikia, treated as accused under section 342, 325 IPC at section 75 of JG Act. Accordingly, after obtaining prosecution sanction from the competent authority, the case has been submitted. The case has been submitted charge sheet against Inspector Deepak Soikia. The charge sheet copy, my lord, I have given, my lord.
List on 28 March. Along with the medical report of the victim submitted by
Next thing, yeah. Next thing. এইটো তেনেকুৱা বিচাৰ আছে এই জুনৰ পৰা অৰ্ডাৰকেইটা চাই চাই আহোঁ মেডিকেল ৰিপৰ্টটো আপোনাৰ প্ৰডিউচ কৰিছে
Vidyapur Community Health Center, as well as Bongaigaon Civil Hospital. That is kept in with the registry pursuant to the
এইটো ৰিপৰ্ট দিছে ন 15 আৰু আছে
order of report, orders of report personally. Report finish. If I did it,
Lordship, may I kindly have a look at the order dated 15/6, Lord.
we have seen
Lordship.
registry look at the orders.
Into medical report, final report, final report. 15/6 partition. Episode.
Nine. Need to register.
দিলে না মেডিকেল রিপোর্ট
Is the report of medical report which was in the also be confirmed. 8522. 29 Nalaga. 22nd.
কেটে দিছে
You come on 22nd.
20 সেকেন্ড
Mr. Sharma, what is the problem? Court asked for the LCR. In July 2021.
Lord,
Why the officers are not forwarding?
I
What
have
is
to
the
take
problem?
instruction note.
Hmm?
I have to take instruction note.
These things we found regular activity. It is not that the cases from Ujaya or something that after bifurcation. The state from Nagaon is good. By order dated 20/07/2021, Tarakotalikan unappeared for the petitioner on call. Even on last occasion, i.e. on 12/19/07/2023, the petitioner remained unrepresented. Notice in this case was issued on 20/07/2021. And records of FT case number 545/2011. Wherein learned Foreigners Tribunal Second Nagaon Assam on 23/10/2017 passed the interim order appointing the petitioner to be a foreigner under the Foreigners Act 1946, who had illegally entered in territory of India on or after 25/03/1971. Impugn in this was called for. Office notes office note told that the said record from the concerned tribunal is there to be received. This is a reminder to the citizens. Foreigners Tribunal Second Nagaon for the records of FT case number 5/2011. Also informed Superior Police Protocol. Further copy of this order is also furnished to Mr. For the necessary order. List on. First April. Next. 23.
Yes, legal lordship. Lordship, answer was called for my lord. Sir, is probably not received my lord.
Rule in this case was issued on 06/12/2019. Call for the records of Lokhimpur FT. That's capital Roman 2, within bracket capital D, case number 526 of 2009. From the office of the Foreigners Tribunal, Learned Foreigners Tribunal, capital Roman 2, Lokhimpur, not Lokhimpur. Very by the impugn final order and opinion dated 29/06/2019. He was declared to be a foreigner under the Foreigners Act 1946, who had illegally entered into territory of India, Uzbekistan, Assam. The specified date of Bangladesh on or after 25/03/1970. Please stop. April.
Here in this case, what is happened, representation submitted. The last second, your chief observed that whether he has received the copy of the. There has been subsequently on 11 itself in this month. After Lordship order on that day, they have served that copy.
They
And
said,
12, it is sent to his house also.
what I get, they have from Dispur, they have already sent the copy to the SP and with a direction to serve the copy and to intimate them. But ultimately they did not get the information, and when there is no proof on with them that they have served it earlier. But they have again given the petitioner on that day.
Is that not?
I have the email I have given, that email is on that day.
You might have communicated from Dispur, that is a different.
Dispur and SP, they said that it has been given, but there is no proof. There is
no proof, no proof.
On that day,
And you know,
they have again.
no proof, what is the outcome? Then
480 days.
No, in
Here 245 days.
kindly see, we have filed the affidavit in opposition in the month of November 23. And in the affidavit in opposition, we have annexed the copy. We have stated, it is petitioner is represented here.
can it be a ground? What is the provision? You have to
No,
serve
representation has been
any order,
submitted.
rejection or acceptance, it has to be furnished to the proceeding.
Yes, that
How it
is.
was furnished?
But I have given the copy from government immediately on the same day. Very similar the email of 30th of August 2023 at 6:31 p.m. The copy has been given to all of them, SP Goalpara, including Goalpara jail, and please find attached at the
So there
attachment
is no-
regarding the subject.
Practically, government doesn't have any backup. After issuing this, you are sleeping over the matter. You were not aware when it was furnished to the PFCD.
And the second email, my lord, they have asked the SP to give the report when it was submitted. But they said that it is immediately given, but they have no proof, my
So
lord.
definitely,
Lordship.
if you have
A-
furnished
again on
it
that
after
day-
his signature,
Lordship.
there is
That
nothing.
is the normal procedure. That is
Now,
normal.
tell us as a court officer. Tell us as a court officer
Lordship.
what you do now.
Lordship. I can't go beyond that.
That is the reason we are asking you. Tell us as a court officer. Forget you are a government council.
Lordship.
Tell us as a court officer.
The re-
Either some persons in the concerned jail are handing gloves with the proceeding or take actions against those persons.
That definitely, my lord, that has to be. Lordship, give me 2 days time, my lord. I'll definitely.
Now, you let us
definitely
assume
come
that you will take action against
Yes, yes.
those concerned
The area
police
officials.
personnel who have
Lordship.
failed to perform their duty.
Lordship.
accordingly. Whatever the cost payable to the petitioner, detaining him in custody.
But my respectful submission is, my lord, in the affidavit we have stated in the month of November, my lord, that it has already been
Might have
rejected and it is in their knowledge, my lord.
his knowledge or the petitioner's knowledge is not the issue. The law says you have to furnish.
Lordship. That is correct. Otherwise, my lord, I have the advisory board opinion and the confirmation of the government, all those things are there. In the writ petition, lordship will find that those things they have not done, my lord. But in fact, my lord, within a particular period, my lord, under the provisions of law, that has to be placed before the advisory board and the advisory board has to confirm. If advisory board is not agreeable, then it automatically goes. My lord, within the period, my lord, advisory board has, my lord, they given their opinion and the government has also given the confirmation, my lord.
That copy is not furnished in the affidavit opposition.
But in fact, in the writ petition, there is no statement, my lord. My lord, what I find, they have given the paragraph comments according to the statement, whatever is made in the writ petition. Kindly see that in the writ petition, it is as per provisions of law, my lord. We have taken the instructions and I'm submitting before your lordship. In the writ petition, there is no whisper that the advisory board or anything. But the procedural requirement as per law that has been done, I'm
He filed a presentation,
he filed representation.
right? This representation was considered and rejected. That rejection was approved by the government.
Rejection, my lord, the detention order has been confirmed. Kindly, my lord, if
That
lordship.
board's decision,
Okay.
board's decision has been confirmed by the government.
But if for a moment, my lord, kindly, if I can place the section 9 of that act, my lord. Nothing এখন বলিব।
NTPS Act on violation.
These grounds they have not taken, but the legal requirement, my lord. But 9C, my lord. 9 kindly, I'm reading 9, my lord, section 9 of PT-NDPS Act. The central government and 9A, the central government and each state government shall, whenever necessary, constitute one or more advisory board, each of which shall consist of a chairman and 2 other persons possessing the qualifications specified in subclause A of clause 4.
Which rule you are using?
The PT-NDPS Act 1988. This is a detention under PT-NDPS Act. Section 9. Detention order has been passed under section 3. my lord. Power to make order detaining certain person. 3(3). Logic. My lord, kindly come to section 9. my lord. For the purpose of subclause A of clause 4 and subclause C of clause 7 of Article 22 of the Constitution, the central government and each state government shall, whenever necessary, constitute one or more advisory board, each of which shall consist of a chairman and 2 other persons possessing the qualifications specified in subclause A of clause 4 of the Article 22 of the Constitution. B, save as otherwise provided in section 10, the appropriate government shall, within 5 weeks from the date of detention of a person under a detention order, make a reference in respect thereof to the advisory board constituted under clause A to enable the advisory board to make the report under subclause A of clause 4 of article 22 of the constitution. C, the advisory board to which a reference is made under clause B shall, after considering the reference and material placed before it, and after calling for such further information as it may deem necessary for the appropriate government or for any person called for the purpose through the appropriate government or from the person concerned, and if in any particular case it considers it essential so to do, or if the person concerned desires to be heard in person, after hearing him in person, prepare a report specifying in a separate paragraph thereof its opinion as to whether or not there is sufficient cause for the detention of the person concerned, and submit the same within 11 weeks from the date of detention of the person concerned. This has been done, my lord, within 11 weeks.
But F here, my lord, and my lord, F also
Yes,
says
F.
different.
I'm coming, my lord. F. I'm coming, my lord. ठीक बोलो.
Maximum period.
Kindly, my lord. When there is a difference of opinion among the members forming the advisory board, the opinion of the majority of such members shall be deemed to be the opinion of the board. But kindly come to F. In every case where the advisory board has reported that there is in its opinion sufficient cause for the detention of a person, the appropriate government may confirm the detention order and continue the detention of a person concerned for such period as it thinks fit. And in every case where the advisory board has reported that there is, in its opinion, no sufficient cause for the detention of the person concerned, the appropriate government shall revoke the detention order and cause the person to be released forthwith. My respectful submission, my lord, is before your lordship is that this case was placed before the advisory board. Advisory board has duly given their opinion in favor of the detention, and thereafter, under section F, it has been confirmed by the government, my lord.
Where is the communication part?
11, my lord, maximum period is given. Yes, sir. 6. It is 6 months, my lord.
No, 1 year.
1 year.
1 year.
More than 1 year.
Read 11.
11. Maximum period of detention. The maximum period for which any person may be detained in pursuance of any detention order to which the provisions of section 10 do not apply and which has been confirmed under clause F of section 9 shall be 1 year from the date of detention. And the maximum period for which any person may be detained in pursuance of any detention order to which the provisions of section 10 apply and which has been confirmed under clause F of section 9, read with section 2 of section 10, subsection 2 of section 10 shall be 2 years from the date of detention. So in normal course, after confirmation, it is 1 year.
Decision of the board.
Yes, my lord. I have the copy, my lord. I'm just giving. My lord.
I have furnished this because, my lord,
It will be.
What is the decision of the board?
Final opinion, Lordship, kindly see on 25th of August 23, before the advisory board, the detainee was produced. The proceeding is there, my lord. And thereafter, Lordship will find the opinion, my lord. The report dated 28/8/23. And the final opinion is there, my lord, at the bottom, opinion. Unanimity, my lord. There is unanimity of opinion of the advisory board
Page,
constituted on,
page.
my lord, the internal page is there, 17, my lord, 17, internal page at the right top corner.
In your affidavit.
I have handed over a report, the advisory board opinion now, my lord. In fact, nothing has been, there is no mention in the repetition, that is why it is not. The advisory board report, my lord. In the first proceeding, it is dated 23rd, my lord. 22nd, board said first.
When he was detained,
He was detained on 13/7. The order is 13/7 and he was arrested after 4 days, after 4 days.
17.
On 17/7. Wow.
order was of 13/7, but taken into custody on 17.
On 17/7. The first meeting, first order of the advisory board is on 2nd of August. They fixed production of detainee on 23rd of August. Then on 23rd, he could not be produced, the detainee could not be produced. On 25th, he was produced. Internal page is there, serial 13. Internal page 13 at the right top corner. The report was given finally on 28/8/23. The opinion, kindly come to last page, internal page 17, opinion. There is unanimity of opinion of the advisory board constituted under Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988 that there are sufficient ground for detention of Mr. Minhas Mandal under the proviso to subsection 1 of section 3 of the act. And thereafter, the next order, last order, my lord. In that bunch, last page, my lord.
Just a minute.
Lordship.
Yes,
In the branch I have given, the last order, kindly see, the last order, it is 1st of September 23. This is the confirmation order passed by the government under section 9F.
30th of August.
30th of August is the representation disposal order. Then thereafter, another order is there. Correct?
It's not there.
Oh, yeah, sorry. Sorry, sorry, it is there. I have. 30. No. Opinion of the board. Advisory board are all. Flag book. Arrival no even. Flag at the book.
Representation was of which date?
The representation was submitted, it is in the report. It is on 18/8, Lord.
18/8.
Yes, Lord. Page 62. Second purpose.
So it should be within 5 weeks from the date of detention,
Yes, Lord.
right? As per section
But
9.
it has to be placed within 5 weeks. And it is to be decided within 11 weeks.
Board decided on 28th of August.
28th of August. It is within 6 weeks. And within 3 months, the confirmation order has to be passed.
Detention was 17th of July.
July, Lord. 17/7. Come on, make it. Come on, make it.
Read section 9.
Lordship. Section 9, Lord. Section 9,
First A is relating to the constitution of the
Constitution
board.
of the Advisory Board.
Then read B.
Then B, save as otherwise provided in section 10, the appropriate government shall within 5 weeks from the date of detention of a person under a detention order make a reference in respect thereof to the advisory board constituted under clause A to enable the advisory board to make the report under subsection A of clause 4 of article 22 of the constitution. So within 5 weeks that has to be given.
When the reference was made.
Okay, it's a month. Well, the first kindly come to the first, my lord, the page in the bunch.
The 2nd of August.
2nd of August, my lord. It is dated 2nd, 2/8/23. my lord. It is within 5 weeks, my lord.
Yes, then
Then, my lord, on that day, the advisory board has fixed the date on 22nd of August for the appearance of the and the production of the detainee on 23rd of August at 1:15. Can you see the next page, next page, my lord, next proceeding on 22nd, advisory board said and the 2 investigating officer, namely so and so are present along with the records of 2 NDPS cases. They have stated that about recovery of the contraband drug from the possession of the detainee and subsequent submission of charge sheet against him. Then kindly come to the next, my lord, the proceeding, order dated 23/8/23. The detainee was supposed to be present on that day, but he could not be. The detainee Minhas Mandal has not been produced due to lack of communication from the detaining authority. On 25/8, the proceeding was fixed. On 25, he was produced. Next, my lord. The detainee Minhas Ali has been produced before us. He has been informed about the materials appearing against him. We have heard him at length. He denies his involvement in drug trafficking. The detainee had submitted a representation against the order of detention, and a copy thereof is submitted to us today. The secretary of the advisory board is directed to obtain information from concerned authority as regard the present status of the said representation submitted by the detainee. 28/8 for report. Then the next proceeding, kindly see, my lord. Report has been prepared. Report. This is a reference under section 9B of the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988, hereinafter referred as the Act, in respect of Mr. Minhas Mandal, son of so and so, seeking the opinion of the advisory board in terms of section 9C of the PIT-NDPS Act 1988. By order number so and so dated 13/7/23, the Secretary of the Government of Assam Home Political Department, in exercise of power conferred under section 3(1) of the Act, passed an order of detention of Minhas Mandal with a view to prevent him from engaging in illicit traffic in narcotic drugs and acting in a manner prejudicial to the provisions under the NDPS Act 1985. The order of detention was passed by the Secretary to the Government of Assam. The order of detention and grounds of detention were served on the detainee. The grounds of detention are summarized as below. It is confidentially learned that Minhas Mandal has started illegal trafficking of narcotic and psychotropic drugs as drug peddler for last several years. Further, he is involved in NDPS case of Agia police station and Bhagwan police station. The district police has already registered 2 cases under NDPS Act. It appears from the record that on 2/2/22 at about 2:45 p.m., on the basis of information received regarding illegal selling of drugs at Solmari Soap, Agia police station, the Agia police team of Agia conducted search operation in presence of witnesses and recovered 1.250 grams of suspected heroin from his possession. On completion of investigation, charge sheet was submitted against you and your accomplice in Agia PS case number so and so and so and so. By charge sheet number so and so, it appears from the record that on 10/6/22 at about 3:20 a.m., information received regarding illegal selling of drug by you at Bhagwan. The police team of Bhagwan PS conducted search at Bhagwan in presence of witnesses and recovered 200 numbers of Yaba tablets from your possession at the possession of the detainee.
Those are not relevant.
Lordship.
Only whether the petitioner was communicated or not. The order passed by the board and considering the fact that the government detained him for 1 year. Yes, what judgment you have said?
This is my lord, in respect of my lord, 6-month period, my lord. And my lord, Yes, my lord. Here, my lord, in this case, my lord, habeas corpus issuance of a writ in the nature of prevention of illicit traffic and narcotic drugs. And
This is a case where,
yes, my
while
lord.
the matter was there before the noble court.
6 months, no detention permission more than 6 months from the date of detention, even where court's opinion is to be dispensed with. Detainee kept in custody. My learned friend was there, also there. Kept in custody without a hearing.
So no order could be placed on that day before the court.
Yes,
And the court found that the period of detention is already over because there is no order extending or keeping detention for 1 year. That is
1
the
year.
reason why this order has been passed.
yes, my lord.
But here in your case, affidavit was filed on 22nd of November 2023.
Lordship. Already, my lord, witness examined, my lord, they are in the proceeding. They are out of 9, 6 already examined. So he was facing trial, also, my lord. During and after 327 days, he was granted bail because he was all along in the custody. Subsequently, my lord, this order.
The order of detention was of 30th of July.
July. So,
was
that
taken
was
into-
subsequent.
He was taken into custody on 17th of July.
Yes, ma'am. Earlier he was on already.
That's the two different cases.
Yes,
were
two
there,
different,
right?
my lord.
So thereafter, the board decided on 28th of August,
Yes.
right?
Mhm.
And the government confirmed it on 1st of September.
Earlier case, my lord. Earlier 20.
We are not on that
Earlier.
because here has to be from the date of the order, right?
Oh yes.
The order was on 13/7, detention was on 17/7. So what is the illegality here?
Because representations submitted before the advisory board also, my lord.
The advisory board passed an order.
But that
resulting-
copy has not been furnished to us till date also, my lord.
My lord,
It has been indicated in the affidavit.
But we have not served the copy, my lord. Indicated it.
Affidavit was filed on 22nd of November, serving you a copy.
The same
That is
representation
the
was,
reason we asked Mr. Draft to read section 9. Is there any provision?
was already, my lord, 245 days, my lord. According to me, my lord, section 9 comes, my lord.
How come?
Because person cannot be kept in custody more than 1 year.
Ah.
Yes, ma'am.
When the detention order was passed?
But earlier also he was in the same case in the jail, my lord. He has been granted bail from this honorable court. Total period is calculated here,
No, no.
maximum for which may person be detained in custody.
Detention prior to granting of bail in that PS case is different from the detention under this Fit and DPS Act.
Definitely.
But that case is also included here, my lord.
The petitioner
have-
wants to
Might
add
be.
that.
But thing is this, here is a case, the petitioner was detained under this
Petitioner already-
1980 Act, right?
Not considered
So-
illegal.
Earlier case was, my lord, in small quantity.
Issues involved in this NDPS matter has to be there. But this detention order was.
But thereafter no other another case was there.
The DAS. He was detained under the 1988 Act, right?
Yes, yes, my lord.
And as per that, if somebody is detained under 1988 Act, period is F, 9F. Here the board decided to have it for 1 year, government accordingly considered it.
Yes.
for 1 year. Then what will be the period?
Because according to me, my lord, in these sets, my lord, papers, itself
Whether
it is
will be under the
evident.
NDPS Act or it will be under the 88 Act.
It is it is, my lord, 88 Act, but here is specifically
Custody has to
mentioned.
be from under the 88 Act or custody has to be from the 85 Act.
88.
Tell us.
$450 days now, this minute. In the same case, case is mentioned here, my lord. Same case is mentioned here, even my rejection of order also. And trial also started, my lord. Already 6 witness examined out of 9. Putting any strict condition, my lord. I have annexed the evidence also, my lord, here. Page 55, my lord. Grounds of detention. This case Agia PS case number 1622 and my lord Bhagwan PS case number 3322. Same case. Bhagwan case. Yeah. First case, my lord, 20C is there, my 22A. This one is, my lord, for a small quantity. And C is, my lord, a subsequent case which was earlier, my lord, petitioner was behind the bar, my lord. 22C comes and my lord, this commercial quantity. In this way, also 6 months of her.
Mr. Das, do you have the act with you?
Yes, ma'am.
Same book you are holding?
Same book.
Page 102.
Yes.
Read this statement and read it.
An act to provide for detention in certain cases for the purpose of preventing illicit trafficking, narcotic drugs, narcotic substance, and matters connected.
Right. So it is very clear, Mr. Das,
Yes.
that whereas having regard to the persons by whom and the manner in which such activities are organized and carried out, and having regard to the fact that in certain areas which are highly vulnerable to the illicit traffic in narcotic drugs and psychotropic substances, such activities of a considerable magnitude and clandestinely organized and carried on, it is necessary for the effective prevention of such activities to provide for detention of persons concerned in any manner therewith. So that provides the detention, right? Now read section 3.
It shall be deemed to have come into force on 4th day of.
Section 3.
Yes, ma'am. Section 3. Power to make orders detaining certain persons. The central government or a state government or any officer of the central government not below the rank of the government specifically empowered for the purposes of this section of the government or any other officer of the state government not below the rank of secretary to the government.
Then
Government officer, state government not below the rank secretary specially empowered for the purpose of this section by the government may, if satisfied with respect to any person including a foreigner that with a view to preventing him from engaging in illicit traffic and narcotic drugs and psychotropic substance, it is necessary to make an order directing that such person be detained. When any order of detention is made by a state government or by an officer or empowered by a state government, the state government shall within 10 days forward the central government a report in respect of the order. For the purpose of clause 5, Article 22 Constitution, the communication to a person detained in pursuance of the detention order of the grounds on which the order has been made shall be made as soon as may be after the detention, but ordinarily not later than 5 days and in exceptional circumstances, and for reasons to be recorded in writing not later than 15 days from the date of detention.
Come to section 2C, definition clause.
Detention order means an order made under section 3.
So this detention is not under the 85 Act. This detention is under 1988. After reading section 9, you have seen, after reading section 3, subsection 3, it is clear that detention order has to be communicated to within 5 days from the date of detention. That was done. After section 9, is there any provision by which the detained custody, who is in custody, detainee has to be informed? Whether it provides only at the time of detention there is an order.
Yes.
Because to be communicated. Is there any other provision? The decision of the board or decision of the government has to be communicated to you?
I'll see, my lord.
Where else? There is so as any provisions or not?
Yeah,
There
my
is no
lord,
such provision. Well,
F.
F read.
In every case where the advisory board has reported that there is in opinion sufficient cause for detention of a person, the appropriate government may confirm the detention order and continue the detention of a person concerned for such period as it thinks fit. And in every case where the advisory board has reported that there is in opinion no sufficient cause for detention of the person concerned, the appropriate government shall revoke the detention order.
So the board has decided for detention.
But that copy was not forwarded to me.
That is the reason we're asking you.
Yes, my lord.
The Act provides that it should be communicated to you.
Nowhere communicated, but then I have to file affidavit in reply, my lord. Against this person
For what?
regarding that copy not forwarded, because my representation itself it is mentioned, my lord, and respondent is also there in the petition. This representation address was also at serial number 2. I have seen, my lord. Detaining at serial number 3, advisory board. He was also addressed, and he is also respondent here in the petition.
The affidavit was filed by the government on 22nd of November. What are you doing all these days? Tell us.
But that is not mentioned anything about, my lord, advisory board.
Page 78. Annexure B to the affidavit filed by the government.
That a rejection order is there, my lord. There is a representation submitted by this and so. Letter number so. After careful examination of all connected records, police, it is seen that there are no justified grounds to revoke the order of the detention. The representation that is submitted by this and so, but here it is not mentioned by the advisory board.
Who will decide? Government will decide or the advisory board will decide? As per section 9? Who will decide?
My lord, advisory board has to, because
So,
first
The
time,
government has to act on the decision of the advisory board or not.
yes, yes.
So
But government has passed this order, but this one of the officer passed, my lord. But
who
it
officer passed?
they have not mentioned, my lord.
Who is officer passed?
The joint secretary to the government of Assam.
Is it?
But here it is not mentioned, my lord, anything about the advisory board. The representation that is submitted by the so-and-so detainee as Mandal Assam has been examined and as there are no valid grounds for revocation of the detention order issued by so-and-so, NP now dated so-and-so, the prayer for the petitioner is rejected by the government Assam, but there is no whisper about the said advisory board says anything and also not addressed there. Simply reject it.
Read the last 3 lines.
Yes. Last 3 line. Madam. The representation submitted by the so-and-so Detinu Minas Mandal district Assam has been examined. And as there are no valid grounds for revocation of the detention order issued by letter personnel so-and-so, dated so-and-so, the prayer of petitioner is rejected by the government of Assam. Copy also not forwarded to the advisory board also.
Which one?
This copy,
The government of their own can decide to reject without the observation of the.
but an
board.
advisory committee is there based on this, my lord.
That is the reason I'm asking you, show us any provision in the act that needs to be communicated to you.
No, I have not communicated anything except this my representation reject order. What has been annexed here. Subsequently, I have come to know that on 11 itself, my lord, 11 of this March, yes, supplied the copy, my lord, on back date. No. Back date will be taken. And 12 also, my lord. Copy furnished to in his own house. 245 days possibly, my lord, after this order, my lord. And already proceedings are
From
going on.
17/7, 1 year yet to be. So.
And my lord, earlier period also comes, my lord, because my lord earlier and one case added here is my lord a small quantity, my lord. So it is
You're
value.
not on that.
Yes, my
You are
lord.
under
Lordship
only
is correct, my lord.
detention, right?
Regarding the effect of that person, my lord.
We'll dispose it of.
Otherwise, my lord, 480 days, my lord.
That will be,
Subsequent
it
cases.
was an arrest
Yes,
and here is the detention.
yes, my lord.
You know
NDPS
what is
case.
arrest and detention?
Yes, yes.
It's just. Yes, next.
Made Pigeon Law. My lord, where the subject matter of this case is, my lord, selection of principal of Kokrajhar College by Assam Public Service Commission.
Why it has been listed today, fixed today?
My lord, huh? Today is fixed, my lord, otherwise. Last it was, I think, listed on 8/11/23. Now, there was difference of mark was, my lord, between the two words. 0.0.
Why before these bands? Should have.
Oh, possibly, my lord, it's a learned single judge Medhi, na?
Yes.
Honorable Justice Medhi is sitting in Delhi with Chief Justice. It's a judgment by Honorable Justice Medhi, my lord. Now, my lord, we assail the selection of the private respondent on 3 counts. First count was, my lord, that interview board cannot give more than 70% marks. If they give more than 70% marks, then they are to, my lord, record reasons. Second point was, my lord, there were 2 aspects.
Yes.
Second was, my lord, the interview board, my lord, consisted of persons who are experts in the field along with others. Now, in this case, so happened, three persons, my lord, they were entrusted with assessment of the academic part. Now, they were also part of the interview. Now, normally the APSC, the practice is person who verifies the academic part, normally they are not associated in the interview.
Is there any bar in that regard?
Yes, my lord, I'm coming to that, my lord. Now, why I'm saying so, my lord, a person who knows the academic marks, he can play foul by sitting as a member of the interview board, because he knows what is the mark they have got, and they can always, my lord, do some mischief, as has been done in the instant case, which I'll demonstrate. Now, my lord, third, how the selection will be made, my lord, in the advertisement it was indicated that it will be published later on, which was never done. That is the most important point in this case. And fourthly, my lord, most importantly, here my lord, academic mark was 40, experience was 10, administrative experience was 10, and interview component was 60. That is where, my lord, everything has gone wrong. And to be fair to the other side, my lord, this point we did not argue before the learned single judge, the last point.
But he participated in the interview process.
Yes. I participated.
Now, if you participate in the process,
no,
when
my
the
lord.
interview process is 60 marks, which is not according terms of the Honorable Apex Court order,
now-
it should be 30.
No,
That's
no, my
what you
lord.
do.
Kindly see, please come to page 150. Now, why this becomes relevant now? My lord, yes, in a given case, it will operate as an estoppel, that I agree. But kindly see the situation in this case. Please come to 151, my lord. These statements are there, my lord. Please come to page number 153.
Yes. Yes.
Kindly see, my lord, Dr. Bonobina Brahmo, that is the appellant. She got 4 marks out of 10 in administrative experience. The other one, she got 0. Then academics, 40 marks. I got 25.37 and the other candidate got 22.27. Now kindly see the interview part, my lord. She got 39, I got 39.67 and the private respondent got 42.83. Kindly see the total and the difference. 0.06. Now, my lord, will kindly come to page 152. Now, after that, page 152 is written by hand, my lord. At page 152, kindly see thereafter 3 columns are there. 5.57, has your lordship got it, my lord. Then 5 and 8, 5 and 6.5. These are 3 persons. One is Rishikesh Borua, as is evident from the first page. Second is Jotin Sharma, and third is Manoj Mishra. They are all, my lord, faculty members of Arya Vidyapith College. Now, of course, they are in different positions. Now, if your lordship kindly comes to the total, kindly see, my lord, this gentleman, Jotin Sharma, has given 18. And I was given only 5. 18 to the other candidate, that means he has given more than 90%. I produce one circular which says 70. APSC says that's a forced circular, it should be 80. Therefore, the court has taken a particular view. I'll come to that. Now, my lord, even if it is 80, where is the reasons recorded? These are the 3 persons, my lord, who took part in that evaluation of the academics. So we say they could not have been part because they knew how much mark is required to make one eligible and how much mark not to be given to one to keep her out of the contention.
Okay.
That is the case, my lord. Now, my lord, most importantly, please come to page 43. That's the advertisement. Page 43.
Yes.
The selection procedure will be notified later on, followed by issuing corrigendum, addendum if required. It was never. Now, what they did, they issued one corrigendum in the next page 44. Kindly come to page 44. In continuation of this advertisement dated so and so, for recruitment to the post of principal, Kokrajhar Government College, it is for information of all concerned that Higher Education Department by letter inform the Commission to follow Government Circular dated 25/2/19 regarding educational qualification for the state post. Kindly see, my lord, regarding educational qualification only, this will be followed. Am I clear, my lord? In view of the said letter, educational qualification as mentioned in clause 4(2) of the earlier advertisement, research guidance is dispensed with for applying for the post of principal in such. Even under the UGC guideline, my lord, for the post of principal, research guidance is not required. Now, my lord, how the mark will be allotted? What would be the component of interview? What would be component? Where is it, my lord? Where have you notified? I mean, all of a sudden, Lordship knows in Ajay Hasia's case, Honorable Supreme Court said that when it comes to recruitment, the interview component could not exceed 15%. That is still holding the field.
Right.
Now, my lord, 60 marks. Out of 110, 60 mean it is more than, my lord, 60%. And I have shown the difference, my lord. I have shown the persons who are responsible for this. I get 5, the other candidate gets 18. That is more than 80%. Where is the reasons recorded? My lord, I came out with a circular where it, my lord, in fact, my lord, APSC has not, I mean, the same APSC is there, my lord, to be honest. This chairman, he claims to be Mr. Clean, then Mr. Clean has shown his own color. If these things are going on, my lord, how can we say APSC is clean? I came out with a circular. I have talked with the chairman, my lord. I myself personally, Ken Chaudhary. I spoke to that chairman. He said, yes, there is one. When I file an RTI reply, initially they don't give the information. One of the members shared that document, my lord. We filed an affidavit. Court took an exception to that this document is forged. My lord, whether it is forged, time will say.
That member's name may be recorded. Then I will proceed on my argument, Lordship.
Don't worry.
Now, question is, where have you notified your selection procedure?
Just a minute.
Yes, I have participated.
Yes, Mr.
Whether,
Chaudhary,
yes.
just a minute. Yes. Come to page 153.
153, my lord.
Let us verify it from
Yes,
APSC.
yes.
Let us verify it from APSC.
Yes.
APSC, tell us. Page 153.
Lordship, interview marks, Lordship. Lordship,
153, please come
Yes.
to page 1. The marks distribution.
Lordship.
10 for administrative capacity, 40 for academics, and interview for 60,
Lordship.
total 100.
Lordship.
These have you notified anywhere before interview?
Lordship, kindly come to my affidavit in opposition.
No, did you notify?
Lordship, it is,
Please tell us.
Lordship, it
Did
is
you-
in the
you have
rule,
notified?
Lordship, and it is in the office memorandum of Higher Education Department, Lordship. It was a notified office memorandum, Lordship. Lordship, kindly come to my affidavit, Lordship.
My lord, this is the copy of the office memorandum. I'm handing 2 copies.
No, no,
A copy.
let me submit, Lordship. That is not the I am
You
referring.
say that you have notified.
it was only from our APSC side, Lordship. I will have to take instruction whether it was notified or not. But in my,
No, in your advertisement, you say specifically you have said in paragraph 43 that you will
Notify this.
notify. Did you notify? Because see, whether the candidates are aware
Lordship,
that there will be on their academics 40 marks.
Hmm.
Administrative.
I am coming
10
to
marks.
one, Lordship. Lordship, this interview was conducted as per, Lordship,
Hmm.
Assam Education Service Rule 1982, Lordship.
Where you have said that
Lordship,
that interview will be conducted as per 1982 rules.
Lordship, this principle is covered under this act, Lordship.
Please tell us. Tell us.
Lordship.
My lord, for the benefit of my learned friend, they filed the affidavit. They said they followed 2019 rules. Para 6, page 72. Para 5 and 6, the 6 and 7, page 76 and 77.
You are following
That
which
19
rules?
rule.
No,
Higher education.
higher education, Lordship.
Now, before that, if your lordship could kindly come to page 76, APSC's affidavit, my lord. Para 6.
1952.
That the deponent begs to state that for selection of principal Kokrajhar Government College, Kokrajhar, a multi-member interview committee has been constituted under provisions of APSC rule so and so, headed by chairman, Assam Public Service Commission. The members are so and so. Then my lord will kindly come to paragraph 7. That the deponent begs to state that selection committee, after assessing the respective merit of both the candidates as prescribed under UGC regulation on so and so, notified on so and so, as well as guideline office memorandum issued by the higher education department, has selected and recommended. Let them show, my lord, that this the office memorandum provides such a procedure.
Okay.
degree. Election के लिए eligibility. My lord, this circular dated 25/9/19, which they refer in their corrigendum, it speaks only about the eligibility criteria. Who are eligible? Who can apply? How that selection will be made? Where is it notified?
Yes. Which provision?
Lordship, paragraph 11, page 78 may kindly be on read, Lordship. And Lordship, on the last occasion, Lordship, I have shared two set of instruction, Lordship, and it is perhaps in the record, Lordship. Paragraph 11, page 78, Lordship. May I read, Lordship?
You tell us that circular
Lordship,
by which 10 marks for administrative capacity, 40 marks for
yes,
academics.
Lordship. That circular, Lordship, dated Government Department of Higher Education issued on 18/11/2011, Lordship. I have already shared, Lordship, Lordship, I am
11.
Lordship,
Is it there in the rules? Which rule?
Lordship, before answering that, Lordship, I'd like to draw your section 6 of the Assam Education Service, Rule 6 of the Assam Education Service Rule 1982, Lordship.
page
703, sir. Assam Education Service Lordship, page number 1703 of Education Manual Lordship.
703.
3 of that Education Manual Lordship. Lordship, this is the principal of a government college and it is governed by the Assam Education Service Rule 1982 Lordship. And page 6 is described the procedure of recruitment. 6 direct recruitment. Direct recruitment to the post mentioned in Schedule 1 of Rule 5 shall be made by the government on the basis of the recommendation made by the commission in accordance with the procedure hereinafter provided. Before the end of each year, government shall make an assessment regarding the likely number of vacancies to be filled up by the direct recruitment during the next year and shall intimate the same to the commission, together with a detail about the reservation and so and so. The government shall simultaneously request the commission to recommend a list of candidates for a direct recruitment in order of preference. The commission may hold such test of or interview as may be considered necessary. The commission shall furnish the government a list of candidates recommended by it in order preference found suitable for direct recruitment and the number of candidates of such list as may be approximately double the number of students. Now, Lordship, it is equal the number after FRBM, Lordship. The commission shall simultaneously publish the list in the Assam Gazette and other places so and so. Lordship, this section 6 empowered the commission to hold the test or interview as may be considered necessary, Lordship. This act does not provide, Lordship, the mode of the procedure of conducting that selection process, Lordship. Therefore, Lordship, we are conducting that recruitment process as per our 2019 regulation, Lordship, APSC. It was already notified regulation, Lordship. Under that regulation, Lordship, there was a clause. If it is for a university principal or so and so, if there is any prescription in the UGC regulation, that we shall abide by that UGC regulation. If there is any service should provide or any regulation holding the fee regulation. But UGC regulation, Lordship, does not provide the marking pattern for the two-stop principal. Therefore, Lordship, we have adopted the government of Assam Higher Education Department notification, which was notified for selection of principal of a provincial college, Lordship. In that notification, Lordship, there was a marking pattern. And that marking pattern, Lordship, we have mentioned in our paragraph 11 of the affidavit, page 78, Lordship. Though it is stated, my learned friend, that 60 marks were allotted for interview. Lordship, if Lordship goes to that notification, Lordship, and a marking, only 20 marks has been allotted, earmarked for the interview, which can be from the own assessment from the interview member. Rest others are all objective based on the document submitted by the candidates. So the submission made by my learned friend is not correct in that point of matter, Lordship. আছে মই ফটো দিছো আগতে দুটা দিছিলো and same is, Lordship, we have described in our affidavit, page 79, Lordship, page 1 more moment, Lordship, of the memo of appeal. And Lordship, kindly correlate the marks we have mentioned in our affidavit in opposition and the marks depicted in that OM, Lordship.
Kindly show us from page 153.
Lordship, 153. Lordship, this mark they have mentioned here after verifying the record, which we have produced before your Lordship, when Lordship was taken up that matter in single bench, and they have been allowed to inspect the documents, they have verified and they have, so now that record is with not me, Lordship. But Lordship,
2019, that selection for the principal, right?
Lordship,
HSLC 5%, correct?
Lordship,
Higher secondary 5%, correct? Degree 5%, correct? Then master degree 5%.
Lordship.
That is all right.
There is no issues on that.
Lordship,
Then total academic marks is
40.
Total academic marks, 1, 2, 3, 4, 5%, 5%, 20%.
20% Lordship.
So it is 20,
Lordship.
but at page 153,
Lordship.
academic maximum is 40. Why?
I'll have to see the record, Lordship, once again. I have shared, Lordship. The one copy I have, in earlier occasion, I have shared 2 copy.
From your record only we are.
Yes, Lordship.
Just for my.
Lordship, in the meantime, Lordship, page 79 may once look, Lordship. That is, Lordship has taken up, taking that instruction, yes. Hmm? 11 of them. Yes, Lordship. Total academic mark is 20. Next, teaching experience 5. Lordship got it, this. And research and publishing, maximum 5. Administrative, 10. Communication ability, 10. Ability to plan institutional program, 5. Ability to analyze and discuss circular development delivery, 5.
This is for principal or for lecturer?
The principal, Lordship.
See at the top.
Individual statement of candidate applying for the post of principal of college.
Okay. Then
And then ability to analyze and discuss curricular development, 5. Ability to analyze and discuss and research support, 5. Ability to analyze and discuss development administration, 5. Ability to deliver lecture program to be assumed so 10. And interview performance, 20. Total, Lordship, 100 marks.
so after that, after page 153, how you have distributed the other mark?
Lordship, that
20
50,
is there for the
153.
academics, metric, higher secondary, degree, master degree. That is 20. Teaching experience 5, 25. Research publics
Lordship,
5, 30.
let me check.
After
Lordship.
that,
Let me check, Lordship.
after that.
Lordship, 153, HSLC 5 total.
20,
Total.
then again 5, 25, again 5, 30.
Hmm.
Then what is 70?
Lordship, this statement I will have to correlate with the
30.
document.
30, then administration 10.
No. Administration,
Suddenly, 20. Page 153,
total 40.
top, you'll see 20 in for the academics. Then teaching experience 5 marks and research publication 5 marks.
5 marks.
10, 20 plus 10, 30.
Lordship,
Administration 10.
10.
So
40.
30 plus 10, 40.
Okay.
The remaining marks, it
No.
will go beyond.
No, this interview, Lordship, where from they have, this-
Tell us from your side. We are asking you.
Lordship, give me 2 days time, I will call for the record and I will have to, from the record only, I will.
Let's come to the record.
Interview
Let's
is
come
the
to the record.
component is direct interview marks is 20. Direct interview marks is 20.
Yes,
So, but we
page
get the
153, yes,
component. We get
yes,
the component, we get the factor is 60. Don't recall.
My lord, as per
Page
their
150,
90 rules,
that-
my lord, interview
one-
components should not exceed 12.2. Their APSC rule says.
No, this is for CC, Lordship, it should not be clubbed with this direct equipment, so and so.
This is for the post of principal.
Principal, Lordship,
Right.
yes, Lordship.
Let us. But if it is,
Lordship, kindly,
if it is a fact that these 3 whoever from those colleges have been asked to
Lordship,
assess the academic marks,
Lordship,
and also they are the members of the selection committee.
Hmm.
They'll be aware about the.
yes, yes, I got your
marks.
point, Lordship. Lordship,
See, when we sit.
those were,
Listen, when we sit for the interview for the selection of judicial officers,
Hmm.
what are the marks they receive in their written examination? We are
Lordship.
not aware.
no,
We are not aware.
no, Lordship, What
That
happened?
is why
No,
sometimes it
those
happens.
three candidates, those three
Some candidates,
members, yes. Only two candidates were there, Lordship.
sometimes even we ask,
Lordship,
that particular candidate has performed so well, why did not?
Lordship,
Ultimately, when the results come, so we
Okay.
find that, oh,
Lordship,
did not get through in the SJS.
Lordship.
What is the reason? Then we, because tallies are given to us,
Hmm.
we see that because in the written examination, they scored much better. Right?
Lordship.
But some students also getting 4 marks in the interview. Their names are in the SJS. Because,
The academic result, Lordship. Maybe, Lordship, it is not.
so definitely if the candidate, those who have these particular professors or lecturers who they have assessed the academic
Lordship.
mark, they will be aware what will be the minimum marks that are required for the interview.
Lordship, that marks is
They will
Either-
be aware.
the API marks, Lordship. Those are API marks, and Lordship is very aware then as to how API mark is calculated under that structural formula of UGC regulation, Lordship.
API marks
That-
also have the educational qualification marks, academic marks.
Maybe no, Lordship. Because and it is not by only one member, it is a 6-member board, Lordship.
Those-
The marks of a one member cannot, Lordship, is not materialized in
How
the
many
allegation.
members were there, those who have assessed the API marks or the academic marks?
API marks on the basis of that regulation,
How many from that particular interview board?
3 members were there,
They have assessed,
assessed, Lordship.
so they were aware for the both the out of both the candidates, how much marks.
Yes,
the API.
and even, Lordship, if my memory goes correct, Lordship, she was awarded more marks in the API.
No,
Lordship.
no, I've given 5.
Lordship,
Whatever.
no, API marks
But
2
they will be
more
aware,
than.
right?
Lordship, API is minimum 190 marks is required, Lordship.
They will be aware.
Away.
What is the total marks there, because. it
No,
is the
that,
self-assessment.
Lordship, I am telling you, Lordship, one
API
thing.
mark is the self-assessment.
Yes, but API marks has no bearing in the interview, Lordship. That is I am telling you, Lordship. API mark is the minimum API marks is required for both candidates. It is a benchmark. Below that API marks, none would be qualified for the interview.
So nothing is, nothing will be calculated.
Yes, no, Lordship.
Whatever the
No,
education
Lordship.
qualification.
Ah,
Yes, education qualification, Lordship, all members has scrutinized, Lordship.
no. Only 3 members.
I am not expecting that to comment from you, sir, at this
No,
stage.
no, but tell us, if all are aware,
Yes,
means the members of the interview board are fully aware.
all
They are
member,
Taking interview.
Lordship, in
that
interview,
This candidate is this mark and this is already.
yes, Lordship, all interview boards are placed, all the materials by the candidates. Everybody, Lordship. It is obvious. It is not a matter of hide and seek, Lordship. Is there, and Lordship, what happened, Lordship? This principal is the administrative post, first thing. And the candidate who is forging a document and placing a, or affidavit is vying for that post of principal, Lordship. On the last order, Lordship, kindly very clear, 11(3). Appropriate order would have to be passed under section 340. Now, the matter is turned,
So as the record.
Lordship, 11(3), Lordship, order may kindly once be record, see, Lordship. 10(3), Lordship, 11(10) order, Lordship,
Okay, I'll answer to that.
11(10). Whatever may be the answer, but why this was committed, Lordship, before the court? Is it expected from a principal? First, he will have to, or she will have to answer, Lordship, why this forgery has been committed before the court. That's why,
80%.
and that event, Lordship, that notification was on based on defined context, Lordship, not in this interview and this type of direct recruitment, Lordship. Now, my learned senior friend has stated that one member has shared. Let that member may be recorded, Lordship. Let him respond. How an official document has been leaked to the candidate, who is his favored candidate. Let everything come into light. And for his behalf, this litigation has been come, Lordship. And one particular member has given more than 80 marks. Let us know, Lordship, who is it member, who shared his forged document.
Anyway, place the record before the court,
Lordship, sure, I will place on that, Lordship.
right?
But Lordship, after 1 week, Lordship.
Why?
Lordship, tomorrow, today, Lordship, is the preliminary examination going on in all of our, Lordship, Assam, Lordship.
Thursday?
Lordship,
Thursday.
no, because with 2 to 3 days, the office will be required for or collection of question papers and others, Lordship. Thursday, Lordship.
Thursday.
Lordship, I'll try. But prior to that, Lordship, I pray before your Lordship. The conduct of the petitioner may also be scrutinized at the same time, Lordship. This is more important than losing or gaining by some party, Lordship. Playing with the court by a forging document should be, Lordship, given due attention from this court, Lordship.
My lord, I have got one more submission. Our information is, my lord, no question was put to the other candidate, and APSC nowadays videographs all this interview, my lord. Did that CD also be produced before the honorable court? Not a single question was asked to the other candidate. That is our information. That statement we have made in the writ petition.
নহয় তাহাঁতি যে কৈছিলে যে 80%, আমি 70% সেই ডকুমেণ্টখন যে আমি যেনেকৈ দি দিছিলো সেইখন
Yes, when, Mr. Chaudhary,
My lord, Thursday, my lord.
Thursday.
will able to place the record on
Lord,
Thursday?
Try, Lordship, while.
If they have the constitution, but it's-
তুমি যে এখন ডকুমেণ্ট
দিছিল
নাই মোৰ তাত নাই
দুটা কপি দিছিল
নাই নাই ফাইলতে নাই
মই ছাৰ দিম ছাৰ দি দিম ছাৰ
এইখন কপি এটা দিম হা
দি দিম ছাৰ
থেংক ইউ ডিপলি হতে
Next, chalo. Okay, nothing to do.
Yes, so Mr. Sharma, you go through the record. Then tell us, because the claim of the applicant is that our father is Oli Sheikh or Olimuddin and not Kalimuddin. And in the order, it has been wrongly shown to be Kalimuddin, right? So that order needs to be, typographical error needs to be corrected. Go through and tell us, will accordingly pass the order. Whether it should be Kalimuddin that will remain, or it should be corrected as.
Regarding NASCAR, which is it projected her as an uncle.
Naskar is the grandfather.
Against the name of police extortion, NASCAR name is there. So Lordship, I think this order is correct because it's not very good.
Why? Order at page
9, Lordship. Petitioner relies upon the paper list of 1966 of state secretary, which contains the name of Kalimuddin, son of NASCAR, serial number 263, and it is claimed that Kalimuddin is the father of the petitioner. Reliance is also placed on Jamapanti in respect to a plot of land in village secretary, which contains the information that the name of Anna Khatun, daughter of Ali Sheikh, has been minted in place of Ali Sheikh. The petitioner seeks to give an explanation that the name of Kalimuddin in the total list of 1970 appeared as Kalimuddin, and from 1997 onward it appeared as Sheikh. Petitioner may produce any relevant material to establish that Kalimuddin, son of NASCAR of the 1966 voter list of place secretary and Ali Sheikh of the 1997 voter list of the same place secretary are one and same person. Now, Lordship, petitioner claim is that Lordship based.
Our claim is that he is daughter of Ulimuddin, not Kalimuddin. That name Kalimuddin should be corrected as Ulimuddin.
I think that was fine.
Our claim is that Lordship Kalimuddin, Ulimuddin, Uli Sheikh are same and one person. Okay. Pedati, may I read lordship? Page 5, Pedati,
Where?
I lordship.
Yes, yes.
Lordship, there it is stated on behalf of the applicant, the petitioner, that the petitioner name of their father name is Kulimuddin, son of Naskar, whose name appeared in the voter list of 1966 of the secretary as serial number 254, and not Kalimuddin, whose name appeared in the same voter list as 253. But it has been mentioned in the order 4/8/2023 that her father name is Kalimuddin, son of Naskar. In fact, Kalimuddin is the uncle of the petitioner. Here, in page 25, 1970 voter list, main restriction notice. Against the name of Kulimuddin lordship, Naskar name is appearing lordship. Lordship may take the matter tomorrow, 30 matter on merit.
Lordship, it is a simple matter, it is a clear case, Lordship. Why not today? This one I wanted.
FT cases come, just verify.
LCR has been received. LCR has been received.
LCR is here, so verify from the LCR.
Yes, yes.
He wants to because the court has already issued notice. This is with regard to the order of the tribunal. Right?
Yes.
But there was strongly recorded in the order dated 4/8/2023. That much only he wants, nothing. The writ petition is challenging the order dated 23/5/2023, whereby the petitioner has been declared to be a foreigner.
Yes.
Now, in the order, before issuing notice on 4/8/23, what court recorded that the petitioner is the daughter of one Kalimuddin.
Yes.
That part is to be recorded. Order of 4/8/2023 passed by this court.
Yes.
Instead of Kalimuddin, it should be recorded as Olimuddin. That's what is prayed for. Do you have the copy of the writ petition?
Yes, sir.
Come to page number 19. Got it?
Yes.
Page 4, paragraph 4.
Others of the second party, police take alias Kulimuddin, son of Naskar, and her mother's name is Zohra Khatun.
Then come to page number 22. Affidavit.
Police take alias Kulimuddin.
Now page number 24. Serial number 254. Page number 24, you got it?
Yes, sir.
Olimuddin. Then you come to page number 26. Serial number 42.
Yes, sir. Kulimuddin.
Now, next part is at page number 28. From 70 to 97, there is nothing. But in 97, he has become Uli Sikh. That's why the order on 4/8/2023, it is considered as that. Now come to the land document. whether it has been annexed or not. It has not been annexed. Yes. Have you annexed the land document?
Yes, Lordship.
Which page? No. Page 33. Page 33 down below.
Noted.
Damela Khatun, Aro Khaleja Khatun, Piti Olisek, Zubeda Khatun, Piti Olisek, Aro Anna Khatun, the petitioner. Okay. So that is why the petitioner has paid for correction of that order of 4/8/2023.
In place of Polymutin,
Right? An illegality. Not since the record have come. We can take up this matter. We'll take up, second effort to review. Okay, we'll allow this,
Lordship.
and we'll direct to release this matter for admission. We'll allow it and it will come for admission.
Oh.
May I please your lordship?
Mr.
Item
Hussain?
number,
Oh, yes.
item number 4, maybe pass over for the day only.
Why?
Arguing counsel, Mrs. S.B. Chaudhary is some personal difficulties, so matter may be pass over for the day only.
কালি এখন single bench আছিল না? কেতিয়া বজাত? অকালি। Take up one in. It's not really here. Take up one in.
Obligation.
But tomorrow, only for the day,
My lord.
he has to be here tomorrow.
Now, he is also suffering from viral fever also.
We cannot inordinately, you appear, that somebody else will appear. It's a review only. Nothing much to do.
Obligation.
May I please, your lordship. My lord, apart from the grounds, I have mentioned from page 10 onwards, worship. From 10 onwards, I have.
Was the error apparent in the face of
Lordship,
last occasion also you asked you?
Yes, lordship. Lordship may kindly come to the order passed by this honorable court, lordship. At page 76.
Yes.
Lordship, we kindly come to paragraph 13. This is all that the petitioner stated in his written statement, which by any count was wholly inadequate to establish the identity of the petitioner as a citizen of India, having regard to the mandate of section 9 of the Foreigners Act 1946, as explained by the Supreme Court in paragraph 26 of Sarbananda Sonowal Sopra. Though petitioner disclosed his father's
You
name,
read it from paragraph 8.
paragraph 8. Yes, sir. This court, by order dated 23 to 2016, had issued notice while requisitioning the case record. An interim order was passed to the effect that petitioner should not be deported from India, subject to his appearance before the Superintendent of Police Border, Borpeta, for furnishing of adequate security. Submissions made by the learned counsel for the parties have been considered. Also peruse the materials on record, including the record requisition from the tribunal. From the record, it is seen that Election Commission of India had ordered intensive revision of electoral roll for the 44 number Zonia LSE constituency in the state of Assam with reference to 1/1/1997 as the qualifying date. In this connection, a house-to-house enumeration was carried out during the period from 16/1/1997 to 15/4/1997. Though the name of the petitioner was included in the draft electoral roll of the said constituency published on 24/7/1997, the electoral registration officer had doubt about the citizenship of the petitioner and got the matter verified by an on-the-spot local verification. Following such verification, report was submitted. On consideration of the report, electoral registration officer ordered reasonable doubt that petitioner was not a citizen of India. He therefore forwarded the matter to the Superintendent of Police Border, Borpeta, on 4/2/2008, who in turn made the reference under the IMDT Act to the tribunal constituted thereunder at Borpeta. We have already noticed the circumstances leading to transition of the reference from one under the IMDT Act to one under the Foreigners Act 1946. In his written statement filed on 2/5/2014, petitioner stated that his father's name was Noyandi Mia, whose name was enlisted as a voter in the voter list of 1966 and 1970 in respect of Zonia constituency. The petitioner stated that he was a resident of Gagalmari village under police station and district Borpeta. He had purchased a plot of land measuring 1 bighah 10 lesas covered by Dag number 920, Patta number 282 at village Salekura under Bagbor Revenue Circle in the district of Borpeta. In this regard, all that the petitioner stated in his written statement by any account was wholly inadequate to establish the identity of the petitioner as a citizen of India, having regard to the mandate of section 9 of the Foreigners Act 1946, as explained by the Supreme Court in paragraph 26 of Sarbananda Sonowal Sopra. Though petitioner disclosed his father's name as Noyandi Mia, who was a voter of Zonia constituency in 1966 and 1970, petitioner did not mention the name of his mother and paternal grandparents, not to speak of his brothers and sisters, if any. But more importantly, petitioner did not mention his date or year of birth. Consequently, there is no disclosure of his age. Even the verification and affidavit shown in support of the written statement did not mention the age of the petitioner. Though the petitioner stated that he was a resident of village Gagalmari,
he also stated that he had purchased a plot of land at village Salekura, which appears to be contradictory, but significantly, petitioner did not mention the date of or year of purchase of such land about the instrument of purchase. My lord, in
Carry on, carry on.
this court has held that if a proceeding fails to disclose material facts in the written statement, adverse presumption may be drawn against the proceeding. No proof can be adduced of fact not pleaded in the written statement. In his deposition before the tribunal on 4/8/2014, the petitioner disclosed his age for the first time as 48 years. If the petitioner was 48 years of age in 2014, it would mean that he was born sometime in the year 1966. Petitioner stated that he was born and brought up at village Salekura. His father's name appeared as a voter in the voter list of 1966, 1970, 1985. He also disclosed his grandfather's name as Birbal Mia. Petitioner further stated that he had purchased a plot of land at village Salekura by executing a registered sale deed on 2/6/1997. In his cross-examination, petitioner stated that he had never cast his vote in any election. His mother's name was Rohimonnesa. She had died before the death of his father. Petitioner further stated that they had shifted to village Gagalmari from Salekura village about 30 years ago. The land at village Gagalmari was in the name of his father. The deposition of the petitioner was a bundle of contradiction. From the deposition, it is discernible that the petitioner was born at village at Salekura village in 1966. On 2/6/1997, he had purchased a plot of land at village Salekura. Father Noindi Mia was a voter from village Salekura under Zonia constituency in 1966, 1970, and 1985. The family had shifted to village Gagalmari from village Salekura about 30 years ago from the year 2014, that is around the year 1984. If that be so, then what was the necessity for the petitioner to purchase land at village Salekura during 1997? Why did the petitioner shift to village Gagalmari in 1984? Mother Rohimonnesa had died before the death of the father Noindi Mia. But when did the father die? What happened to the purchased land at Salekura? Why was the land at Gagalmari in the name of the mother when she had died before his father? After her death, who is the pattadar of the said land? The evidence of the petitioner is totally silent in this regard, and there are no explanation of this. Having noticed the contradiction as above, we may now proceed to deal with the exhibits. Exhibit A is an extract of the voter list of 1966 in respect of Zonia constituency. In this exhibit, there is only one voter, Noindi Mia, son of Birbal Mia, aged about 28 years. He was shown to be a resident of village Salekura. If Noindi Mia was 28 years of age in 1966, it would mean that he was born sometime in the year 1938. Exhibit B is an extract of the voter list of 1970 in respect of the said constituency. There are two voters, viz. Noindi Mia, son of Birbal, aged about 33 years, and Rohimonnesa, wife of Noyanuddin, aged about 21 years. They were shown as resident of village Salekura. At this stage, we may overlook the discrepancy in the name of Noindi Mia and Noyanuddin, as well as the year of birth of Noindi Mia, which as per Exhibit B is 1937, which is at variance with the year of birth of Noendi Mia as per Exhibit A. The next exhibit is Exhibit C, which is an extract of voter list of 1985 in respect of the said constituency. Here again, there is only one voter, this Noendi Mia, son of Birbal, aged about 45 years. He is known as he is shown as a resident of village Salekura. Even if he ignored the discrepancies in the name Noendi Mia and year of birth, which does not tally with the years of birth as per Exhibit A and Exhibit B. What cannot be overlooked is the disappearance of Rohimon Nessa, wife of Noendi Mia. She is conspicuous by her absence in Exhibit C, though she was present in Exhibit B. What happened to her? There is no explanation to this. Interestingly, according to the version of the petitioner, they had shifted to Gagalmari village in 1984. But this exhibit Noendi Mia is shown as a resident of Salekura village and not of Gagalmari village. Exhibit 22D is a certificate dated 27/1/2014 issued by the Gaubura of Gagalmari village, certifying that petitioner was the son of late Noendi Mia and a resident of village Gagalmari. From this certificate, what is discernible is that Noendi Mia had expired. But when did he expire? Where a petitioner has not stated anywhere. This certificate shows that petitioner is a resident of Gagalmari village. As discussed above, according to the petitioner, he had shifted from Salekura village to Gagalmari village during 1984. Such facts or the truthfulness of the contents of the said certificate could have been tested had the Gaubura testified before the tribunal, but the petitioner failed to produce the Gaubura before the tribunal. Therefore, this contention hardly has any probative value. That apart, the Gaubura of Salekura village neither issued any residency certificate in favor of the petitioner nor testified before the tribunal that petitioner was born and brought up at village Salekura or about his present age, parent age. Exhibit E is a self-serving affidavit by the petitioner shown on 4/8/2014 stating that his father's name was Noendi Mia and his grandfather's name was Birbal Mia. Noendi Noyadi Mia and Noyandi is one and same person. The affidavit is no proof to establish linkage of the petitioner with Noendi Mia. Exhibit F is an alleged sale deed of land dated 2/6/1997. In this document, petitioner is shown to be a resident of Salekura village and the ceded land was also of village Salekura. As already discussed above, while examining the written statement and the evidence in sheet, it had been notified that when the petitioner had purchased land on 2/6/1997 at Salekura village, he had already shifted to Gagalmari village in 1984. Therefore, he could not have been a resident of Salekura village. What happened to this land at Salekura? Did the petitioner purchase new land at Gagalmari village after shifting to Gagalmari village 1984? Why did the petitioner purchase land at Salekura in 1997? These questions remained unanswered. Thus, the upshot of the above discussion is that the narrative presented by the petitioner suffers from multiple material contradictions, rendering his version highly improbable. On a thorough assessment of the evidence tendered by the petitioner, it cannot be said that petitioner had discharged his burden under Section 9 of the Foreigners Act 1946. Consequently, we do not find any ground in the to interfere with the order passed by the tribunal writ petition is devoid of merit and is accordingly dismissed.
Yes, very clear, you see. Yes, yes. Here or one. Ready to decide. Very good. Now, let us see. Very difficult. Now, let's see. Oh, let's see here. Okay. Now, in the 24th, let's see. Here are here is the if it here my person of here here. Please take your seat, Mr. And not. It's not. Either the other, it's not. The other. So, technically, it's not that. Because it's in- These are the- the auto was- Yeah, even error acting, it's- Not that is not, it's over, it's not, it's over. These are not clear. Yes. Yeah, let's. I mean, again. That is correct, but- that is, how he has linked with his father. What is that? Nothing, nothing, and it's nothing public. There's no. So, Mr. Hussain, where is the illegality? That you can show, could show from this order? Yes, Rich.
Lordship, may kindly come to paragraph 13, Lordship, of this of the judgment and order
Yes,
passed by
yes,
this.
please.
Page, the relevant portion is page 80, Lordship.
Yes.
Lordship, may kindly see from the second line, though the petitioner disclosed his father's name as so and so, who was the voter of Zonia constituency in the year 1966 and 1970, petitioner did not mention the name of his mother and paternal grandparents, not to speak of his brothers and sisters, if any. But more importantly, petitioner did not mention his date of year or date of birth. In this, Lordship, I would like to refer two paragraphs of the judgment passed in Hyder Ali case, Lordship.
Listen. Do you have the copy of the writ petition?
Yes, Lordship.
You have the annexes with you?
Yes, Lordship.
You have annexed your written statement?
Yes, Lordship. I have a written statement is at page 57.
First of all, you come to page number 41. Then turn to page 42. All these are
Yes, Lordship.
photostat
Extract
copies, right?
Yes, Lordship.
Down below verification. You read
Lordship.
page number 42. Read the verification.
Page number 42. Case number 42, there is no variable.
Can you read petition?
Lordship.
Read petition.
Read petition of the
You have or don't have?
read petition of
Petition copy I have annexed lordship. It is from page 19 onwards lordship. Petition.
19 of what, Mr. Council?
19 of the review petition.
Review. You don't have a copy of the writ petition.
Copy of the writ petition is not available.
Is not with
I
you.
have annexed lordship.
Okay, is there in the review? Oh, give it.
I have
Give my
annexed.
copy.
No, that's even if it is, it doesn't matter.
an except new teacher.
19.
Your written statement,
Written in review petition lordship, page 57. And the verification is at page 58 lordship.
it's 59. 60. Got it?
Yes, lordship.
Then read the verification.
Yes. I, Rohimuddin, son of Noyandi Mia, aged about.
So it's blank.
Yes, lordship.
In the affidavit, you have not annexed the affidavit. You have not annexed the affidavit. Mr. Payeng. Give me one. Nothing. One is affidavit, one is very. Affidavit is not in the note, but in the record is also in the affidavit it is not. They have-
Lordship, one affidavit is there, lordship, regarding anomalies in name and address that was exhibited before the learned tribunal, lordship, at page 55.
What kind of affidavit?
Age is mentioned, age is mentioned there, lordship, page 55.
As what?
Regarding anomalies in his father's name, lordship.
Can it be rectified by filing an affidavit? Is it possible? Was the law laid down by the ethics court in this regard? What is the law?
Lordship, regarding anomalies in names and address and
Mr. Council, for so far as anomalies concerned,
Yes.
it's okay, it can be used.
Lordship,
But your main purpose is to show the linkage.
lordship.
If the affidavit cannot show you the linkage, what is the purpose of having the affidavit? You may say that A means B, B means C, C means D. Okay, we accept. But you have to show your linkage with your father. Your father who was supposed to who was in the voter list.
Yes, lordship.
If the linkage is not established,
Page 32.
affidavit does not serve any purpose.
Lordship, page 32 is the voter list, lordship. 1966, appearing father's name, lordship.
No, that is okay. The keyword is linkage. How do you link yourself to your father? That's okay.
Mr. Pai, this is the original record. There are two pink ink marks. Bookmarks are there, two. One is the verification, one is the affidavit. Does the verification show to him, Mr. Singh? Both in the verification and in the affidavit, he did not mention the age. Okay, this is one.
Yes.
Now come to the cross, Mr. Hussain.
Lordship.
Come to the cross.
Yes. 62. Page 61. Cross is at page 62, Lordship.
Cross is at page 62, right?
Yes.
Yes. Now, here you have stated this was shown on, you have not given the dates. Why? Why you have not given the dates?
Okay.
Your cross was available in your read petition at page 45. From there you can read. Mr. Pang will get his cross there in the record down below.
Cross page. Page 62 date is there, Lordship. Page 62.
Let it be from the original. You got it? Give it to us. We'll get it for you.
Yes. 45.
You got it?
No.
Give it to us. Give it to us. Ask Mr. Hussain to read.
Cross part, Lordship.
Yes, yes.
I never cast vote in any.
I was born. It was, your evidence was recorded on August 2014, right?
Yes, Lordship.
Good.
Uh,
Kindly read.
I was born, Lordship. I was born and brought up at village Salekura.
You are a resident of village Gagalamari, right? Gagalmari.
Present resident of
Mm.
village. My father's name appeared in the voter list of 1966, 1970 and 1985 at serial number 389, 446 and 379. House number 132, 132 and 275 of village Salekura under Zonia LSC, Exhibit A, Exhibit B and Exhibit C. Gaubura of village Gagalmari issued one certificate in respect of my present residence, vide Exhibit D. My father's actual name was Noendi Mia and grandfather's actual name was Birbal Mia. And in that respect, I have executed one affidavit vide Exhibit E. I purchased a plot of land at village Salekura by executing a registered sale deed on 2/6/1997, Exhibit F. Cross. I never cast vote in any election. My mother was died before the death of my father and my mother's name was Rohimon Nessa. We shifted to village Gagalmari from Salekura about 30 years ago. I have not submitted my certificate from the Gaubura of village Salekura. Our land at village Gagolmari is in the name of my mother, and I have not submitted any such land document of my mother.
Fine. Now, in your cross recorded on August 2014, you have categorically stated that 30 years back,
Yes, Lord.
you have shifted from
Village
village
Salekura.
Salekura.
Yes.
So 2014 minus 30,
84.
19.
84.
Are you sure it is 1984? Yes, you do the
Yes, Lord.
2014 minus 30.
$74.
Yeah. 80.
Do one thing. You add 74 with 30,
Also, Lordship, 84.
84. So you are sure that in 1984 you have shifted to village
Yes.
Gaglamari, right? Gagalmari
Yes, Lord.
from Salekura. Right. Now, where is your cell deed?
Yes.
Page number 44. That's in vernacular. Mr.
Cell deed.
Payang, that green flag mark is there. In your review petition, you have at page 43
Yes, Lord. Yes, 43.
and the vernacular is page 44.
44. Lord.
Now, at page 44, you can read vernacular.
Yes,
Good. Read page 44.
page 44. বরাবর রহিমউদ্দিন, পিতা নয়নদী, জাতি মুসলমান, পেশা কৃষি, সাং সালেকুরা, মৌজা জনিয়া, থানা
And now just come to page number 49. On which date it was executed?
3597.
30th of May 1997. For my brother, kindly read page 43.
Page 43. This cell deed is made between Rohimuddin, son of Noyandis, by caste Muslim, by profession cultivation, village Salekura, Mouza, Junior, PS, and subdivision and district Borpeta, and Abdul Barek, Abdul
You have not
Baset.
given the date on which it was executed, but anyway, it
Vernacular
is
is
available in your vernacular.
Vernacular, Lordship. That is.
In your evidence, you have categorically stated that in the year 1984,
Yes,
you have shifted to village
Gagal.
Gagalmari.
Yes.
But while purchasing the land and you are continuously staying at village Gagalmari, right? Your certificate by the concerned Gaubura is also from village Gagalmari. So we did not prove that document. Is that land? Are not these contradictions are there?
Yes, okay.
So what is the error apparent on the face of the record? Tell us.
Lordship. That is there, Lordship.
Kindly tell us straight away, all these contradictions are being available in your case record. Kindly show us the error apparent on the face of the record. Review it.
Lordship,
Don't stick to para 30. Tell us.
Lordship, some
When these contradictions are there, it is your case
yes,
and it is nobody's case.
some
It is only the Rohimuddin who is supposed to prove that he is Indian under the Foreigner Act.
I am admitting, Lordship, some contradictions are there, Lordship.
If there are contradictions, how the tribunal will have to believe? It's a fact only known to you.
Lordship,
Facts not known to the tribunal.
Yes, Lordship.
Facts not known to the anybody else.
Lordship.
Only known to the proceeding.
Lordship is aware earlier these cases were done before the time, not so seriously as is done
Seriously,
nowadays,
not
Lordship.
Seriously, we want to ask you
Lordship,
straight away.
earlier occasion, if
Show us any error apparent on the face of the record in this particular order that needs to be reviewed.
Lordship,
What do you mean by error apparent on the face of the record?
Lordship, I am referring to page
You have read para 13.
yes,
And
Lordship.
brother has straight away asked you, how you have proved your connection with your father, link document to establish.
One link document was there, the Gaubara certificate, but that was the Gaubara was not examined, Lordship. That is there. Otherwise, yes, Lordship. Otherwise, in other documents, Lordship,
Anything
lawyer,
else? Anything else?
Lordship, for a moment, Lordship, may kindly, I may be allowed to submit, Lordship. The coordinate bench of this honorable court, Lordship.
We are not on other matters. We are here, particularly in this matter.
Lordship.
So was error apparent face record for the review.
Lordship, as per judgment of the Muslim Mandal judgment, Lordship, in paragraph 7, Lordship, there are some anomalies is shown there, Lordship, and some considerations were taken, like the purchasing of land in other village. Lordship, I may be allowed to read that portion, Lordship.
There is no fault. A person residing in Mumbai can purchase a plot
Yes,
of land at Gwalpara, Dhubri, anywhere.
Lordship.
There is no harm in that.
Those things were also brought into consideration while deciding this case, Lordship.
Whatever. A person, anyone in India they can purchase,
Lordship.
right?
Lordship.
So
That is one of my submissions, Lordship. That
purchasing land is fine,
yes, Lordship.
but you belongs to which village when you have purchased that land?
Lordship, somebody
Kindly
living.
tell us you belong to which village when you purchase that land?
Well,
You
that-
belong to village Gogolmari
I-
or belong to Salekura?
I were a resident of village Gagolmari, wrongly because his other family
How many
members,
wrongs?
other
How
family
many
members,
wrongs to be added to make it correct?
Lordship, other family members will residing at village.
Where you have mentioned that in your written statement? Where you have mentioned that in your written statement, that other family members are residing at village Salekura?
Lordship,
Can you go beyond your reply to the show cause? Where you have stated, in which paragraph?
in read petition, Lordship, I have mentioned.
In the writ petition will not do. Can you go beyond your reply?
Lordship, may kindly see the written statement. Only 2, 3, 4 paragraphs
You, whatever
Doubly
you
was
have,
completed.
Mr. Hussain,
Lordship.
whatever the procedure has said before the concerned council, that much has been placed. The council will not know what Rohimuddin was been doing. Whatever Rohimuddin has stated, the council has written. Now you cannot say that.
Requirement of the proceeding will better know the council, Lordship.
If you have certain legal issues, just tell us. If there is nothing, don't make any further submission. Show us how this order of the court is bad in law. Because we are not sitting here in appeal, we are in review. Show us the effort, that is error apparent face of the report, we consider.
My first submission is that while deciding this case, some irrelevant considerations were taken into consideration, Lordship. That is apparent from paragraph 17 of the judgment, Lordship.
Paragraph?
Paragraph 17.
Okay, then
Paragraph 17. Paragraph.
next.
Then paragraph 21 also, Lordship.
Irrelevant consideration taken into consideration.
Lordship. And paragraph 24.
Okay, paragraph 7, paragraph 24. What else?
Then, Lordship, the affidavit which was denied to consider, Lordship, regarding anomalies and names.
So was the law. What is the law?
Lordship, there is a
Okay, affidavit. Second, affidavit showing the correction of the names,
Lordship,
not considered.
not considered.
Then not
Lordship,
considered by whom?
neither
By
by
the
the
tribunal or
neither
by
by the
the?
tribunal nor by this honorable
Oh.
Lordship. Then, Lordship, regarding anomalies in ages, 2, 1, 2, 3 years, this variations, Lordship, in different voter list. Somewhere 1 year, somewhere 2 years, somewhere 3 years. These were also not considered. paragraph 21, Lordship.
Then
Mainly these three submissions, and Lordship, one more submission regarding the written statement that is inadequate. Yes, Lordship, it is apparent inadequate. I also admit, Lordship, but that inadequacy cannot deny my claim, Lordship. That is paragraph 14 of this judgment, Lordship, at page 80, written statement referred, Lordship. And in this regard, I refer the Hyder Ali judgment, Lordship.
what is there?
Lordship, may kindly see paragraph 14 of Hyder Ali. Sorry, Lordship, paragraph 42.
Hyder Ali decided when?
Hyder Ali decided 33/20/21, Lordship.
When you have withdrawn the writ petition, the SLP. This one.
9/12/19.
Will it be applicable?
But later on, these things were considered. Lordship, these are all, your Lordship knows, these are all illiterate persons. They are not at all about law, neither law nor fact, Lordship. They are guided by some learned counsels, Lordship. Lordship, these may be some mistake done by the learned counsel, Lordship, and for the mistake committed by the
Tell him the Foreigners Act, section 9.
no, Lordship, I am not on that,
Tell him the
Lordship.
Foreigners Act, section 9.
Uh,
Nothing else. Can we go beyond that? Can you go the law established by all these section 9 of the Foreigners Act? The law laid down by the Constitution bench regarding section 9 of the Foreigners Act.
My humble
Can we
prayer
go
is that
beyond? Whether a person is whatever, illiterate, literate is not the issue. Can we go beyond section 9
because, Lordship,
as
these
decided by the Constitution bench?
because of this illiteracy, Lordship, these things could happen, Lordship.
It is
My
not
humble prayer
illiteracy.
is that Lordship may kindly allow me a chance, Lordship. I will, at this stage, I will prove everything, Lordship. That is my humble prayer, Lordship. If the matter is remanded back again before the tribunal from the written statement stage, I will be able to prove everything,
Under
Lordship.
which provision we should return back or remand back the matter? Tell us, under which provision of law?
I am leaving it for your Lordship consideration.
Kindly
Lordship.
tell us, Mr. Hussain, if, see, what we can do is within the periphery of law. Show us the law by which we should remand back the
Lordship,
matter.
Writ Court Dome has
We are not
ample
sitting
power,
here
Lordship.
for any other writ, we are sitting here for certiorari, right?
Writ Court has ample power, Lordship. Lordship can.
That is the
refer-
difficulty. That is the difficulty. We cannot go beyond whatever in the certiorari, right? You have lately recent judgment of the Honorable Justice Paliwala, right? If you go to, that is why we are asking all of you to read that judgment. Because the Honorable Apex Court noticed that in some of the cases while exercising the writ jurisdiction under certiorari, they have exceeded. And that is why the reasons specified all those judgments of the Honorable Apex Court discussed and found that some of the writ courts have exceeded their jurisdiction of certiorari.
Lordship, at this stage, I can neither develop the written statement nor I can develop the evidence or cross-examination, Lordship. Therefore, I am praying, Lordship, before your
Yes,
Lordship.
Mr. Pine.
Well, first of all, your lordship may kindly see yesterday, day before yesterday itself. The petition under the petition, review petition has been filed, my lord. Under section 10 and my lord, the order 47 and rule 1 of the CPC. So what rule 1 rule says, my lord? The CPC, my lord. So first of all, we have to see what is review, my lord. So the order 47, my lord, says with regard to the, my lord, delay, a application for review shall be filed by petition and shall be filed within 30 days from the date of the judgment or order sought to be reviewed.
What is that provision?
47.
Order 47.
47, yes, because he has filed this petition under.
No, limitation itself is provided there.
30 days.
Yes,
No, if it is under 40 CPC, 30 days.
47 CP.
CPC. Yeah, fine. Yeah.
Otherwise also, because it is same code, na?
Mhm.
It will be 30. Otherwise also, it will be 30 days. Just like ETP.
Mhm.
Na?
Order 47, rule 1 and 2. In rule 2, my lord, it is clearly said. Rule 1, my lord, the court may review the judgment or order, but an application for review will be entertained in a civil proceeding except in the ground mentioned under so and so of the code, and in a criminal proceeding except on the ground of error apparent on the face of the record. The application for review shall be accompanied by a certificate, that is, I'm ignoring. Second, my lord, an application for review shall be by a petition and shall be filed within 30 days from the date of the judgment or order so to be reviewed. It shall set out clearly the grounds of review. So 2 points are, my lord, necessary here.
Mr. Payang, you're reading from which
My lord,
order 47?
order 47, rule 2, my lord.
Rule 2.
Yes.
Kindly read rule 2.
Order 47, man. An application for review shall be by a petition and shall be filed within 30 days from the date of judgment or order sought to be reviewed. It shall set out the clearly the grounds for review, man.
I have not found it.
Sit down.
Mr. Payang, I have not found it. I don't know. From where you read.
My lord, reconcile limitations. Proper, my lord, like just a minute. Okay. Okay, what should we do? I'm sorry, my lord, probably there is some mistake on that.
Are you reading the same?
Same book. Limitation may be prescribed by, I think, Article 124,
Yes.
Limitation Act. But the CPC itself, I have not seen anywhere that it says 1 week, 30 days or 1 month or whatever.
I have. No, probably this, I have misconstrued somewhere. Let me examine this issue once again, madam. I'll see that. But even after thereafter, madam, I'm, for the time being, my lord, I'm leaving that point, my lord.
Probably your argument is that since it's under order 47,
Yes,
so it will
it
be,
will come under, my
it
lord,
will come under the limitation.
limitation act.
So 30 days has been
30
prescribed,
days has been prescribed, so it has to be, it cannot be filed beyond 30 days.
but they have said they want to Supreme Court, they
Yes.
came back.
My lord, that limitation act says, my lord, again, I'm coming to the limitation act, my lord. Going to the Supreme Court will not help them under section 14 of the, my lord, limitation act. Because.
But they are saying, because they went to Supreme Court, it should be reviewed.
No, that's why, my
Mr.
lord,
Hussain,
my lord.
in your prayer portion,
Yes, sir.
in your prayer, you have taken that, you have mentioned that.
My lord.
I don't know what you mean by that, but you have mentioned it.
They are mentioning is that, my lord, there should be condoned for delay.
No. Right, para 14, case 15 of the review petition.
Yes, para 14, they have not made a directly said. They file a statement, they have given a statement. The petitioner begs to state that there is delay in filing the review petition because after receiving the certified copy of the order passed by the Honorable Supreme Court, immediately he could not meet advocate the Guwahati High Court due to financial crisis, and thereafter due to COVID, he could not move around and earn money. In this way, the delay occurred, which is neither deliberate, intentional. Rather, my lord, he has not said that prior to approaching before this Honorable Apex Court, there is no explanation. Prior to approaching before the Apex Court, there is no explanation because he approached Apex Court much later. And the approaching of Apex Court, my submission is, my lord, approaching Apex.
Just a minute, Mr. Payan. Hmm. Hmm. Okay.
How do you like?
Hmm. Supreme Court. See, we'll come to that limitation part, Mr.
Yes.
Payang, but one thing I was trying to point out was in the prayer portion, page 16, they're saying that the order should be reviewed because in view of the Supreme Court order of 9/12/19.
This is
Mr. Hussain,
this is in addition.
has the Supreme Court said that you should review the order? It just says that it just allowed you to withdraw the SLP with liberty to approach the High Court for review.
Lordship, this is just
So-
other part, Lordship. And or Lordship, this is other part, Lordship.
No, this is drafted not by a layman, it is drafted by a lawyer.
Yes, Lordship. It is other part, Lordship. may kindly
Judgment
say-
order should be reviewed because of Supreme Court's order 9/12/2019.
This is other part, Lordship, may kindly say, the page 16, cause as to why the order dated so-and-so past in devolution or so-and-so shall not be reviewed, and or thereafter be declared that he is not a foreigner within the meaning of section so-and-so of the Foreigners Act, and also this is.
Yes,
other
and
part.
also in view of the order dated 9/12/2019,
Yes, Lordship.
Yes.
you are trying to take support of the Supreme Court's order. Why?
Lordship, because the.
Supreme Court has not said
granted us
anything.
liberty.
Supreme Court has only given you liberty to
Yes,
withdraw
Yes, Lordship.
on your prayer.
Yes, Lordship. Therefore, Lordship.
So you're trying to create a situation in which there is some observation or something like that
Lordship,
from the top court.
Lordship may kindly take into consideration the previous part also, Lordship.
No, definitely not.
Of my prayer, Lordship.
What brother is pointing out correctly is this, if you read your prayer portion,
Yes, Lordship.
It's like direction given.
two parts are there, you are saying?
Yes, Lordship.
Just, we are reading for you. Right? Call for the records of WPC number 550/2016 and other relevant documents. Issue notice.
Drawn in 1998.
See, no point of issuing those days because we
Yes.
are only here to review of the order.
No,
of
no, my lord, why
2017.
review delay part, my lord? 98. The process initiated, my lord, thereafter in
Under IMDT, then again converted to
Yes.
Foreigners Act.
Foreigners Act. And then
Everything is there.
he
That
was
has been-
declared foreigner ultimately on 21/9/2015 by the Foreigners Tribunal. Then he approached the Honorable Court, my lord,
2017.
2017. After 2015, he approached the Honorable Court in 2017. There is delay of 2 years. After 2017, he approached the Honorable Apex Court in 2019.
Mr. Pine, those cannot be taken in this round of review.
No, no, what
have
I am
seen his
saying, my lord,
conduct.
the delay part.
We have
What,
seen his conduct.
what is the intention of my lord doing all this? My lord, he, after Honorable Apex Court,
Mr. Pine, that order has been stayed. So at this moment, we cannot say anything on that.
So only my submission is, my lord, with regard to delay, and that's it. Even though it may not be, my lord, mandatory for filing, my lord, delay condonation petition for 226, but
Who
my-
said that?
no, my lord, there's what
Who said that?
as per my
The
lord,
judgments of the apex court,
yes, this is necessary.
very clear. Nowhere the apex court said in filing a
Yes.
review petition in a writ proceeding, you don't have to file, you can file beyond. That's the why yesterday, last Friday. Brother has asked you, that means you can approach this court for review after 15 years, 50 years.
They have to
whatever
file,
you
my
feel
lord.
like. Nowhere apex court has laid down that. In fact, you will see numbers of judgment where there are review petition.
Yes, review,
There has to
review,
be a delay condonation petition. There are numbers of judgments of
yes.
the apex court. That also
Now-
review in a
They-
writ proceeding before the high court,
They have not
not
filed
only
it,
before the apex court.
they have not
Under
filed it,
Article
my lord.
32.
First of all, they have not filed it. And they have given an explanation here, only one line statement that due to COVID. And I could not collect money, so I could not approach this honorable court. And first of all, my lord, limitation, even though they explained it, that is not reasonable and that cannot be acceptable at this moment. And they have not filed, my lord, delay condonation petition for that.
Mr. Bank, see, when this notice was already issued earlier in this matter, 18th of February 2022. Right?
Yes,
So, okay, you have taken that down.
that is,
Since
that,
the matter has not yet been admitted,
yes, ma'am.
it is always open.
That is a ground, number one, my lord. Secondly, my lord, what is the, my lord, with regard to review? What is the ground of review here in this case, my lord? Main issue. My lord, when the review can be filed? Only on three grounds, my lord. First of all, error apparent on the face of the record. If there is any discovery after the judgment, even after due diligence, they could not produce, my lord. And any other reason, my lord, which is reasonable. Now, he has taken, my lord, their main contention in the review petition. And from the entire, my lord, the grounds. What, my lord, it is cited here in this review petition. The main, my lord, their contention is that the view taken by this honorable court is not correct. Can it be a ground for review? As per the,
Judgment. Justice Paliwal's judgment, very specific.
yes, Kamalas Burmas,
Even if it is, the order is wrong.
yes,
There is a
yes, ma'am.
not. That will get it in particular.
It does.
SCC online.
Did you say? Yes, ma'am. Okay.
Wait, it's set.
No. That's right.
My lord, with regard to review, the statutory question. Review, my lord, your lordship may kindly say this is 2013 ATCC 320.
Just a minute, just a minute.
Access to statutory.
That particular paragraph, when there is order mistake.
Yes. Para 50, my lord.
I think there is an order paragraph, even the order of the tribunal is bad. Its finding is there. Very, get a print out here.
No, that's the judgment. Maybe 2 years. 2 years.
This is an SCC on. No, it is not. Is there another air it took somehow till the FCC has not come.
SCC online.
But in AI it is. You go check it. There are printed.
Twenty 2023, my lord, SCC online 996.
There are 36.
No, para 52, my lord. 2023, SCC online, SC 996.
Yes.
Para 52 may kindly be seen, my lord. From para 21 itself, your lordsmith. The first cardinal principle of law that governs the exercise of extraordinary jurisdiction under Article 226 of the Constitution, more particularly when it comes to the issue of writ of certiorari, is that in granting such a writ, the High Court does not exercise the power of appellate tribunal. It does not review or reweigh the evidence upon which the determination of the inferior tribunal purports to be based. It demolishes the order which it considers to be without jurisdiction or palpably erroneous, but does not substitute its own views for those of the inferior tribunal. The writ of certiorari cannot be issued if an error of the law is apparent, can be issued if an error of the law is apparent on the face of the record. A writ of certiorari, being a having prerogative writ, should not be issued on mere asking. This is the first point, my lord. Secondly, para 52 says, my lord, the second cardinal principle of exercise of extraordinary jurisdiction under Article 226 of the Constitution is that in a given case, even if some action or order challenged in the writ petition is found to be illegal and invalid, the High Court, while exercising its extraordinary jurisdiction thereunder, cannot refuse to upset it. Can refuse thereunder, can refuse to upset it with a view to doing substantial justice between the parties. So this is the point, my lord. Article 226 of the Constitution grants an extraordinary remedy, which is essentially discretionary, although founded on legal injury. It is perfectly upon for the writ court exercising the flexible power to pass such orders as public interest dictates and equity projects. The legal formulation cannot be enforced divorced from the realities of the fact situation of the case. While administering law, it is to be tempered with equity, and if the equitable situation demands after setting right the legal formulations not to take into the logical end, the High Court would be failing in its duty if it does not notice equitable consideration and mold the final order in exercise of the extraordinary jurisdiction. Any other approach would render the High Court a normal court or appeal, which it is. So,
What is the other judgment you said, 2013?
my lord, that is with regard to review. Review, in fact, this is 2013, my lord. 8 SCC 320. Well, when review can be lies, review can be, and when review cannot be, well, the entire case, it is discussed, but summary has been given. Your lordship will find para 20 onwards, madam. In fact, in this case, all cases has been discussed.
That's right. Para 20.2.
Yes, 20, madam, 20, 20.1 when review maintainable, and 20.2 when it is not maintainable. As your lordship has already pointed out, what is the error apparent? First of all, my lord, 20.1 it says, when the review will maintainable. Discovery of new and important matter or evidence, which after the exercise of due diligence was not within the knowledge of the petitioner or could not be produced by him. That is not the case here. That is not the case here, my lord.
This is order 47, all the 3 grounds.
Yes, all the 3
Grounds of review.
Grounds of review. Then the mistake or error apparent on the face of the record, that is not there. And any other sufficient reason that has been explained, my lord, any other sufficient reason. The words any other sufficient reason have been interpreted in so and approved by the court in so to mean a reason sufficient on grounds at least analogous to those specific in the rule. We have rule, madam. So these are the grounds where review lies. When review would not lie, my lord, was not maintainable. 20.2, my lord, when the review will not maintainable, a repetition of old and overruled argument is not enough to reopen concluding adjudications. What my learned friend is arguing, that there are discrepancies which were not considered. These are, my lord, repeated arguments. This was argued in the repetition stage also. These were considered. It is not that these were not considered. This is in the, my lord, judgment, it is reflected. Then, my lord, minor mistakes of inconsequential import. What your lordship has rightly pointed out. What is the link? My lord, I accept there may be under all what my learned friend has argued. Those are mistakes. Those are mistakes in the judgment. But only thing is that what is the link? How you have proved the link? There is no, my lord, no link at all. He himself admitted only link documents, the Gawara certificate was not proof. He admitted. Thereafter, what is more? That is the only consequent issue, my lord. If he could prove the link, and if that link was not discussed by this honorable court, that could have been a different issue. But if some mistakes are there here and there, that will not, my lord, affect his case. But there is no minor mistakes, my lord. Even there is no minor mistake at all. Minor mistakes of inconsequential import. There is no consequential, my lord, facts which were committed mistake by this honorable court. Number 3, review proceeding cannot be equated with the original hearing of the case. You want the original case to be heard again by going through the judgments and etc., my lord. Review is not maintainable unless the material error manifests on the face of the order, undermines its soundness or results in the miscarriage of justice. Then 5, a review is by no means an appeal in disguise, whereby an erroneous decision is reheard and corrected by lies only for patent error. That is, then the mere possibility of 2 views on that subject cannot be a ground of review. His main ground is that there is possibility of other review. This honorable court has taken some other view, so it may be reviewed. That cannot be much. The error apparent on the face of the record should not be an error which has to be fished out and searched. My lord, that there is no error. In fact, even though they are trying to read out, my lord, they are fishing out some error if there is anything. That is not allowed in the review. Then the appreciation of evidence on record is fully within the domain of the appellate court. It cannot be permitted to be advanced in the review petition. So we cannot appreciate evidence again, my lord. Here at this is this. It is if they go to the apex court, there it may be, my lord, but here we cannot appreciate evidence in the review petition. then review is not maintainable when the same relief sought at the time of arguing the main matter had been negative. My lord, their argument was that the opinion of the tribunal may be dismissed, my lord, may be my lord, set aside, and the petitioner may be declared Indian, not foreign. So that again, same, my lord, their prayer is the same prayer, that the opinion of may be dismissed, opinion may be, my lord, set aside, he may be declared Indian under the Foreigners Act, Section 2 of the Foreigners. So that was the submission in the writ petition also. That cannot be. So these are the grounds on where the review is not maintainable and where the review is maintainable. Now there is, my lord, from the reading of the all grounds, everything was considered in the, my lord, by the reasonable court while disposing of the, my lord, writ petition. So this review petition is devoid of any kind of ground, and hence this may be dismissed at this very initial stage.
Anything else?
No, there are numbers of judgment, but let it let my lord, your lordship may kindly refer this judgment also 2022. 2022.
2022.
Yes, my lord. SCC online, SC 1034, my lord. This is also on the ground review. When lies all the judgments, earlier judgments.
SC 10.
1034, my lord. 1034.
Party's name?
Party's name, my lord, Sri Madhusudan Reddy. S. Madhusudan Reddy versus D. Narayan Reddy and others.
S. Madhusudan Reddy.
Yes, madam. This is, everything has been discussed in this case, madam.
2022 SCC online, SC 1034.
Yes, madam.
Okay.
Only earlier, even this Kamalesh Burma was also considered.
What are the facts in this case? 2022 SCC online?
No, but this is with regards to.
In what circumstances the court has?
This is with regard to tenants and tenancy.
Okay.
And now, that is It is with regard to review, how far it is, when it can be accepted and when it cannot be, when it is maintainable and when it is not maintainable. One judgment, your lordship may kindly see, this is 2021, 7 SCC 206.
206.
Yes, ma'am. 2021, 7 SCC 206. This is small order, madam. This is by Honorable Chief Justice now.
What is the relevant para?
My lord, just para number 2 and 3, my lord, small para. In fact, I can read, my lord, it's a small judgment.
Read.
The review petition have been referred by the state of Goa both with delay of 650 days and both with delay of 651 days, and diary number so and so, and diary number so and so, all four with a delay of 970 days against the judgment of two judge bench in the court of Goa Foundation versus Sessa and so and so. Now, in accordance with Rule 2 of Order so and so of the Supreme Court Rules 2013, an application for review of judgment has to be filed within 30 days of the date of the judgment or order that is sought to be reviewed. No cogent grounds have been furnished for delay between 20 to 26 months by the two parties in filing their application for review. The judges comprising the two judges benches of Goa Foundation, so and so, retired from the court on 30/12/2018 and 6/5/2020, respectively. The state of Goa preferred its whole review petition in the month of November 2019 after Justice so retirement, while Vedanta Limited preferred its whole review petition in the month of August 2020, right after so-and-so's retirement. Such practice must be firmly disapproved to preserve the institutional sanctity of the decision making of the court. The review petitions were aware of decision of this court. Keeping in mind of the above, we are inclined to dismiss these review petitions on the ground of limitation alone. However, in the event, we also find that no legitimate grounds for review of the judgments of so-and-so have been made up and dismiss this review petition on merits as well. So this is with regard to Ben's hunting and it.
No, that
When
is
a
because after the retirement of both the judges.
Yes, both
they
judges.
have filed.
One was filed,
After retirement of one
one
judge
judges,
and
and
the other
another
petition is
two were
after
filed
retirement,
after
both
retirement.
the judges.
So delay, this is on ground of delay. After 650 days, that was filed. And two grounds it was rejected. First of all, that is only due to delay. And secondly, there was no sufficient grounds of review. In fact, in this case also, there is no sufficient grounds of review. Delay, I have explained, I have said. In fact, in delay, I want to argue one point, one more point. Under Section 14 of the Limitation Act, the bona fide, the time bona fide has to be considered if the petitioner wrongly approached in a wrong forum with bona fide treatment. Here is the case, they approach the Honorable Apex Court, knowing everything that he has a review jurisdiction.
No,
Or-
that's what in the
It's
Friday
not,
itself we say,
it's
two
not-
options.
Yes, two options. He had two options.
Selected one option.
He
Cannot
taken
come
a
back with
one
the other
option.
option saying that.
There,
time
when he
period is-
dismissed, he came back. On that ground, he cannot take the limitation.
no, it's not his
limitation-
case. It's not their case anyway.
Yes.
That because of this, we should be accommodated. We had gone there. Somehow we should have come here. Nothing like
This is
that.
not- And that is why in one of the judgment of the Apex Court clearly laid down. But
Yes.
the two options are there.
Two options are there.
Then the other options, the limitation will come to an end.
Yes.
Because you have selected to go in that option.
Yes, that's why my submission, he has taken that option. So limitation will not count. Limitation will, the limitation will,
Limitation will run from day one.
day one.
What is your calculation?
My lord, it is near about 4 years, my lord. Because the judgment was passed on, the judgment of his honorable court was passed on.
7/11/17.
Yes, ma'am. 7/11/17.
Review petition filed on 22/2/2021.
Yes, madam.
Thousand and 161 days. Minus 30 days.
You have calculated.
Hmm.
See.
Hmm.
February.
Hmm.
More than 1520 days.
How much?
More than 1520 days. 1500
1500.
days.
Okay, Mr. Hussain.
I am also relying on the documents regarding scope of the
Yes, please submit.
2008 SCC 437.
2008
SCC
Hmm.
437.
Okay, then
Then
any
also
relevant paragraph?
paragraph 23.
Okay. What is the proposition?
This is on what? Delay?
No, scope of review.
Scope
Okay.
of review.
2004 to SCC 150.
150. Any relevant paragraph?
Relevant paragraph 30 lots.
13.
30 lots.
30.
Another lots.
This is also on scope of reviews.
2005 4 SCC.
This is also 2004 SCC.
2005 4 SCC.
2005 4 SCC.
741. It's 741.
Then
Paragraph 88 90.
all this to your scope of review.
And one order of this honorable court regarding section 14 of the Limitation Act. 2015 5 DRT.
Hmm.
397. Paragraph 21 and 22.
What is the finding? Para 21, 22.
The purpose of section 14 of Limitation Act 1963 is to afford an opportunity to the litigant to seek redressal in a proper forum after he had prosecuted bona fide and in good faith a civil proceeding in a court which did not have jurisdiction or which was unable to entertain the proceeding for causes of like nature. The underlying policy of section 14 of the Limitation Act is to give a protective umbrella to the litigant against the bar of limitation. When
How
the-
it helps you? How it helps you?
And where have you laid the foundation?
In that particular judgment, that is why we ask you how the proposition, we know about it. That the fact is that there is the Capellan approach. The Buddhists believe that appeal is in that particular forum. Later on, it was realized that that is not the forum. It's separate. As to, in that background, section 14 of the Limitation Act has been discussed. Right? But here, against an order of a division bench passed by High Court under Article 226, only two forums are available. Either review or
SLP.
an SLP before the Honorable Apex Court, which you have done. How this proposition will help you?
That is what my submission was, madam.
And you have not laid the foundation also to rely upon this judgment. That wrongly we had gone there.
That is not your case. That's what I've been pointing out. In fact, during the deliberation,
No delay condemnation
Brother has pointed out.
petition is there.
Anything else? Gahal Pashan. Gahal Pashan. Take it to siding, side deploy. No, they're doing it. Not possible, but this is time. Heard Mr. Imran Hussain, counsel for the appeal. Let's read petition. Also heard Mr. Deepa extending counsel from Department of Assam for the respondent numbers 2 and 3. Give 2 dates, huh? Friday, last Friday, and today. Hearing dates. Arguments are hardly. Moderator. It is not. Then yes, everything, that is not written. That somewhere it has to be. Right, absolutely. I have what? In which? Here it is, review petition, the concerned read petition should happen there. Right, Lehman. Yes, we have resolved your.
Obliged, Lordship.
Next.
Lordship, kindly adjourn the matter, Lordship. Kindly adjourn the matter. I am not well, Lordship. I am also maintaining Lordship fasting. Any date, Lordship.
We'll have it tomorrow.
Day after tomorrow, Lord.
See, his bans you have to remember. Brother is there only for a few days now.
It's possible, Lordship, day after tomorrow.
Tomorrow. Give it. On the prayer of the council.
Yes, sir.
petitioner list. Printer কি হবে printer? Printer কি হবে? ঠিক আছে। একবার